Point judge. I would like the commissioners to introduce themselves, and I will start. And my name is Professor Olive Mugenda, commissioner representing the public. Thank you. To my right.
Good morning, my Lord Judge.
Good morning.
I am Philomena Mbetemwilo, the elected representative of the Supreme Court to the Judicial Service Commission and the Deputy Chief Justice of the Republic of Kenya.
Thank you.
Good morning, Judge.
Good morning.
I'm Patrick Shohi, representing Public Service.
We thank you.
Good morning, my Lord.
Good morning, sir.
I am David Majanja, Judge of the High Court and male representative elected by the Kenya Magistrates and Judges Association.
A big pleasure, my Lord.
Good morning, my Lord.
Good morning, sir. Sorry. Good morning.
I'm Oluwande Evelyn. I'm a Chief Magistrate, the female representative of KMJA. You're welcome.
A big pleasure. This should be our first meeting.
Yes, my Lord.
Welcome.
My Lord, good morning. My name is Machari Anjero. I represent the Law Society of Kenya.
Oh, thank you, sir.
Good morning, Judge. My name is Felix Koske. I represent the public.
It's a big pleasure, and thank you.
Morning, Judge. My name is Mohammed Warsame. Welcome once again.
Asante sana. Thank you, and thank you again.
Very good morning, my Lord. Kehara Kariuki. I am the Attorney General, and I'm a member of the Commission by virtue of my office.
Thank you, sir.
Thank you very much, Honorable Judge. We will break after 2 hours, Judge, but if you need a break before that, you can kindly let me know, and then we'll have that break.
Thank you.
So, Judge, I will start off the interview, and I would like you to briefly tell us about yourself, your career, maybe 2-3 minutes, your honor. Please go ahead.
Thank you, Gautier. My name is DK Njage Marete. No additives, no subtractions, no additives. And the authority for that name is the Registration of Persons Act, Chapter 107 of the laws of Kenya. Of late, I've been receiving various baptism by my employer, 5 months later by the Chief Justice Emeritus. In 2012, when I was appointed a judge of the Employment Court, the press put my name as DK Jambi Marete. Well, I'll go by what you say because I lived in the 60s as a boy, in the 70s, and I know the danger of protesting a nickname or anonym. Thank you. DK Njagi Marete was born 61 years ago. We attended various schools, starting with the Kirege Primary School at some place called Chuka in Tharaka Nithi County, Alliance High School between 1974 and 1977, Meru High School 1978 and 9, the University of Nairobi between 1980 and 84, the Kenya School of Law. In 1984-85, clearing on the 31st of July 1985. On academics, thereafter I went to work at the Attorney General's chambers. I did 17 years and 65 days at the Attorney General's chambers. Rising from State Council 2, we started as a legal assistants, but activated so that we also got the title of State Council, which appeared like it was privileged. So in 2002, I left the Aegis Chambers and I went to buy for a place, member for NIFI, which was unsuccessful. In 2003, very early 2003, when the whole country was in a very celebratory mood, I came back to Nairobi, very empty-handed, and I started a small practice about 100 meters from where we are seated, and lasted 11 months. In November, 23rd of November that year, I joined the Teacher Service Commission as the senior principal legal officer, and lasted 5 years and 40 days. On that, 70 days. On the 70th day, I was issued with a letter of retirement on public interest, and I made a departure to my home at Ongata Rongai. We started the practice at Ongata Rongai this time, which lasted 3 years, and in that 3 years, we also combined it with teaching in 2012 at the African Nazarene University. In that time, my days at the TSC, I had also done my master's program at the University of Nairobi, LLM. And earlier on, I had done a diploma in theology through the Presbyterian University of East Africa, or the Presbyterian College then. And that is who I am in terms of academics, and in terms of history of work. On the 12th of December, not December, but July, I was appointed a judge of the Employment and Labor Relations Court, which place I sit to date. Thank you. Good chair.
Thank you very much, Your Honor. Your Honor, why do you feel that you are the best qualified candidate to be our next CJ?
One, I know myself. I know my abilities, and they have been tested. Right from the day one, work-wise, at Sharia House, the Department of the Registrar General, on the from 1st of August, 1985, to January 1987, 1.5 years, I was a celebrity at Sharia House in terms of performance, in terms of meeting the requirements and the happiness of the people of Kenya. And when I was transferred to Nyeri in January 1985, there was like a riot on the corridors of the third floor, the public trustee. When you send him away, who will serve our interests? Who will serve us in this scale? Throughout my career, Nyeri 8 years, come back to Nairobi in 1974, the same assignment, did another 8 years. The Teacher Service Commission, the Judiciary, it is shiny. It is shiny, and anybody who walks around me can testify to that extent. That and my other abilities makes me the most suitable candidate for this kind of adventurous assignment, the Chief Justice of the Republic of Kenya.
Thank you very much, Your Honor. That question is, as you know, Judge, leadership is key to the transformation of institutions. So I want you to tell the Commission specific achievements, that can be attributed to your leadership in your career.
I have not sat in a big office like you had. I sat in Sharia House 1.5 years. I sat in Nyeri 8 years, in the Department of the Registrar General and later Administrator General. I came back to Nairobi in 1994, did another 8 years, left, went to some private practice of some kind. I went to the Teacher Service Commission. Look at my track record. The best I could have done in that circumstances is head a station in Nyeri, head a division in the Teacher Service Commission, teach at the African Nazarene University, manage myself at in my various fora of private practice. And the success story in that, you cannot succeed if you are not very organized, if you are not very focused. My hallmark is that one, is a good leadership. I put that very, very clearly in my self-assessment, and all those attributes which you find in my self-assessment tell you that I am good to go. I am very, very good material for this kind of assignment. 2, daring is my other name. There is nothing which shakes me. This office requires a very, very daring person, a person who doesn't antagonize anybody, but will be able to work with anybody and resist anybody who comes in to fool around with the office and the entire establishment, the judiciary as such. So we have qualities, personal attributes, which very much tell the story of our abilities, our performance, our leadership strategies, our leadership abilities, etc., etc. We are saying that we are capable, we are able, we can organize this team called the judiciary to excellence in several senses of the word.
Thank you, Your Honor. My last question is, I'm sure you must have thought about your vision for judiciary when you applied for the job. So what is that vision, Judge?
I am a result-oriented leader. What ails the judiciary from the onset is the backlog of cases. I have a history where I don't live with backlog. I have a history where I was able to do 47 judgments and rulings in a month, in December 2017. I would sell this to everybody else who works in the judiciary, both the judicial officers and our other staff, so that we are able to transform to workers and people who have the interests of the country at heart, and be able to clear this backlog in the next 1095 and 3/4 days. And that is doable if everybody looked at himself as a Kenyan, looked at the issues Kenyans have, and wanted to address them. That is very, very doable in the next 3 years, and I would do that. If I am not able to do that in the 3rd year, I'll be able to take account and say we failed, and answer to Kenya and to my people in the judiciary, and tell them we have failed because of A, B, C, D, and E. And in any case, I would even see the developments in the course of time and work on those developments. The issue of failure, the issue of inadequacies, and clear those so that in 3 years, Kenya will be free. And you bring your matter in 365 and a quarter days, you have the matter cleared. We release everybody to go and do their things. How would we be able to do this? Capture 2 main stakeholders. One is the workers, the staff of the judiciary. And when you do that and motivate them, make them happy, they were awarded tea and water by the Chief Justice Emeritus, Chief Justice Mutunga. Give them a ban or 2, motivate them, work with them. I work with everybody from a standpoint of equality. Sit with these people, whatever their status, whatever their rank. Teach them, consult them, work with them. This is doable. And I'll repeat that 1,000 times. It is doable, and I'm capable of doing it. The other stakeholder is the people of Kenya, and the people of Kenya must also be pleased and made to join us in the struggle to clear our effects. A backlog is not a causative of the judiciary alone. We have our other stakeholders. There is the Law Society of Kenya. There is the people of Kenya, which is the mainstay of the litigants. What you do is capture the people of Kenya as a second stakeholder. Please them, work such that everybody who comes to court leaves with a smile. And I've achieved that. I see it even in this time of Teams. Over the screen, everybody who leaves my court leaves happy. If you sell this to the people, to the workers of the judiciary, and every Kenyan came here and left happy. Every time they join, they come for their issues in court or out of court. Kenya will just join us, fundraise for us, and we will have all the facilities we ever wanted. It will be a success story. Every other person across the globe would fundraise with us, and we'll be there, good to go. A judiciary which is funded, a judiciary which is doing its best, a judiciary which everybody comes to benchmark, a judiciary which is a success story, and that is it. All rid of backlog. 360 days, and there you are. Your matter is finalized.
Thank you, Honorable Judge. You have talked very well and very ably about your strategy for backlog, resolving the issue of backlog. What else in terms of vision? So backlog is one. At least there is one or two other things that you focus on.
Backlog and technology have to work together. We would have to invest on technology, invest on manpower in that sector, invest on the devices, the materials which are required in technology, so that we are able to advance in that area. We can never go back to the past. To a large degree, I think COVID-19 is a blessing in disguise. We are so advanced now, we cannot go back. So build on that, equip this place technologically. You liaise with people like the Ministry of ICT, the ICT Secretary. You liaise with other experts in that area, CCK, other stakeholders who are in the private sector, and they come up with a well-built ICT sector. This now assists you to get through with the issues of a backlog and other functional essentials of the judiciary. Two, the staffing of the judiciary. I am not sure that we have adequate staffing in this sector. Those are areas that we may have to look at and make sure that we have adequate staff to be able to implement our programs with people who are able, people who are available, people who are willing. The issue of judges is also another very serious factor. Look at this. We are expecting to do excellent, groundbreaking jurisprudence. But you cannot do groundbreaking jurisprudence when you have 30 matters to do, not even 30 is on the lower side, it's 40, 50 matters, judgments and rulings to do within 60 days. So we require additional staff. And that reminds me of the issue of the 41 judges who are still to come here. These ones should be here by like yesterday. We do not have them. What have we done about that? We've gone to court, we've gone bra, etc., we talk about it, we shout about it, that kind of thing. I have the background of labor relations and employment, and the background of family law and succession. These are not areas where we must run to court over our issues. We talk and resolve these issues. We conciliate and resolve the issues. We negotiate and resolve the issues. So in the circumstances of our 41 judges, I mean, what options do we have now that we have tried the formal process and it is not yielding results? If it is not yielding results, it is not immediate results. We employ dialogue and diplomacy. If I land in the office of the Chief Justice of the Republic of Kenya in the next 1 month or so, in the second hour of my sitting in that office, CRJ and the Deputy Chief Justice with me in a serious meeting. These are members of the Judicial Service Commission. And what shall we be talking about? It is talking about the judges, the 41 judges. And which direction would I push them? We have, say, matters in court. I'm not even sure of that one. We have a stalemate between ourselves and the executive, particularly His Excellency, the President of the Republic of Kenya, Uhuru Kenyatta. So why won't we devise, brainstorm, and come up with something to sell to the JESC so that we are able to foment our way forward in this matter towards dialogue, towards diplomacy, towards a resolution of the matter, so that we start from the start point of 200 judges. We have 150 now. With 41, that will be 30 to 200. And that would go a long way in assisting us a clear backlog and make this place functional. So I, the Chief Justice, the CRJ, and the Deputy CRJ, Deputy Chief Justice, have the first session, an hour or two, come up with a strategy or something to present to the JESC. And in the next 2 or 3 days, the JESC is sitting on the matter. In a week, this side of the bargain is done. So we have a formulated strategy for dealing with the approach we are going to use to deal with the matter. Get a meeting with His Excellency. Get a team of 3 or 4 members of the judiciary, of the JESC. Walk down there, have a chat. In less than 4 weeks, that issue would be resolved. And if it is not resolved, we don't close it there. We thrash it further. And within a month, at most 2, we make up our mind as to how to go about it, whether to go to court and pursue it endlessly, or whether to strategize differently and get a solution to the issue. Those are the options we have. My choice would be a choice of dialogue, a choice of talking, a choice of conciliation. This is government. And government is not separated. We talk about the robust independence of the judiciary. We talk about constructive interdependence. Government is complementary. The 3 arms of government must complement each other, so that we have, the people of Kenya feel the finesse of government. The people of Kenya get the fruits of government. The people of Kenya appreciate that they did not envisage a situation that everybody will be running their own show. Therefore, get a different approach to the issue. Go dialogue, go diplomacy. If you don't have adequate people who are versed in diplomacy or in that field, employ them, involve them, get a solution to this matter in at most a month. And I think that is also doable.
Thank you very, very much, Your Honor. I will now request the Commissioner Honorable Acting CJ to ask you further questions.
I thank you. My Lord, let us look at ourselves from within so that we can say where my Lord will take us next. We have an instrument called the SJT, which is our current blueprint. At every page of it, we emphasize bottom-up approaches, strategies, and purpose-driven leadership. That is done with an intention to achieve for ourselves an agile, modern, and responsive judiciary. My Lord, with particular emphasis on our subordinate courts, please give us your conception of purpose-driven leadership, how that can be engendered in our courts, and more particularly the subordinate courts and the tribunals. Please be specific to the area that I have directed my Lord to.
Purpose-driven transformation or systems of getting results intend or would focus on where you have identified what you want to get. The main product we have here is output, dealing with the matters that we have in the magistrates' courts, in the tribunals. So what we would require to do is educate everybody of their place, and within themselves form leadership circles, so that these people are educated on their targets, what we require to achieve from their work. These people are guided on how to do this, lead themselves to achieve the set goals. These people are shown and monitored so that they are able to do that on themselves. We would have supervision from other sectors, but within themselves, this should be emphasized so that we have internalized the leadership in the tribunals. We have internalized the leadership in those so-called subordinate courts. They become their own masters, and they are capable. The differential between those who are in the magistrates' courts, in the tribunals, could be a differential of age. They are trainees, professionals like us. In so little time, they will be our age and dealing with the bigger things. So motivate them, educate them, train them, and give them the steps of leadership, the methodology, etc., etc. When they are educated, when they are trained, when they are shown the way, you lead by example, you demonstrate.
My Lord, may I? Is that to suggest that all the things my Lord is talking about now are not in place? That the people we have in the subordinate courts, which is actually our highest constituency, are not equipped in the manner my Lord is suggesting?
I am not suggesting that. I've been to various courts. I've served in various stations. In fact, I'm a Kenyan. Even without being in the judiciary, I would know that they do that. But now we are talking about result-driven leadership, where you emphasize that you do your targets. These people are, are educated. They are shown the importance, because we may have issues now because of things like laxity, things like lack of firmness, things like lack of knowledge. So re-engineer this system, motivate these people, and I believe motivation would go a long way in getting them to do things faster, better, and achieve bigger results. We have them agreed, but we require that they are motivated they are monitored, they are educated, they are loved.
Thank you, my Lord.
And
thank you.
Thereby we achieve what we wish to do.
Thank you.
Yes.
Ours could be described as an extremely unique institution where judicial officers, who include judges, have some special protection called independence. But my Lord appreciates that independence does not stand alone. Would my Lord please tell us what it stands with and how, as our team leader, my Lord would foster that independence with that other something that I would like my Lord to tell us what it is on the judicial and the administrative function of my Lord, the Chief Justice.
Thank you, my Lord. The history of this the judiciary has a situation that the issue of independence of the judiciary was overplayed, such that when performance contracting came in some maybe 10 or 20 years ago, it was resisted so badly. We have come to learn that we are accountable. And accountability is a part of our system and our agenda. So we cannot run away from accountability on the pretext of independence. We have an employer. This employer has invested in us, and it must get results. In the first, transformation framework, we laid the grounds for transformation, and this was effective. So in the second phase of the transformation, we had the SJT sustaining the transformation. In this transformation, we put in measures like performance contracting, where every person in the judiciary would be gauged on what he produces. This is accountability, on the grounds of accountability, and accountability becomes part and parcel of what we must always emphasize, so that at the end of the day, today, we know what judge so and so has done. We know what officer so and so has done. We are able to tell Kenya, or the people, our employer, that this is what we are doing, this is what we have achieved. We have not achieved any better because of A, B, C, D, and E, and therefore, we are accountable to our employer. Kenya must reap results for investment. I have never doubted that, and they would sit in and ensure that every staff of the judiciary, judicial officer included, is accountable. You are able to tell us, this is my bag of goodies I have packed for Kenya.
I thank you, my Lord. There is something we've been doing since 2018, and it is called reorganizing ourselves. The organization review. Would my Lord please discuss what we are doing there, with particular emphasis on the objectives of the reorganization towards enhanced service delivery?
I am not an insider in that kind of...
Yes, my Lord, you are an insider. Would you please discuss that matter? My Lord has been here since 2012, right?
Please repeat the question.
Since 2018, this institution of yours and mine has been undertaking a reorganization review with a view to enhancing service delivery. My Lord, the question we ask is, what have we been doing? Is it achieving the intended purpose? And now that you ask that, I repeat the question. I'll add a rider to it, what my Lord is doing about it.
Service delivery is a must for all of us, and we must do the delivery in an adequate manner. What we have done is enhancement of resources, so that we are able to enhance, to facilitate our staff to deliver. We have also come in with an effective, system of monitoring delivery of service. We are able to monitor performance through the DCRT, through the monthly returns, etc., etc. What we are saying is that we put in place facilities, or we put in place systems which would make us do better in terms of service delivery. We put in trainings which would make our staff, particularly at the level of down there, the support staff, be able to facilitate those who are judicial officers or those who are up there to perform. So we have, I cannot complain. We have done so well insofar as delivery of service is concerned. We are able to issue our returns on a daily basis. We are able to record our judgments through Kenya law.
Let's do this, my Lord, if you allow me.
Please.
As my Lord the Chief Justice,
yes,
if God allows that to happen, then you become our team leader.
Yes.
This reorganization starts from the top and goes to the bottom. Remember, my first question was on our bottom-up strategies. How would my Lord the Chief Justice ensure that each one of us in this institution is with everything we are doing?
Firstly, it will require training. Secondly, it will require effective leadership, so that at all levels we have supervisors who are able to get everybody on board. We don't have any loose heads, so that people are just scrambling over nothing. They do not know what they are doing. So leadership is very, very effective. 2, education through training is would be another factor which would facilitate this kind of thing. And like you said, bottom-up approach, so that everybody becomes a leader. We are able to get things moving up and moving down, so that the two approaches, bottom-up and up-bottom, become effective, and thereby we get what we want.
All right, my Lord.
Involve all the stakeholders, involve our staff, so that they become partners in what we are doing.
Thank you, my Lord. Let me first ask a direct question.
Please do.
And then we can have a discussion thereafter. What is our current strategic plan cover? What period does it cover?
I am not aware of that one.
Which means then that my Lord would not know the strategies, particularly the policies that are discussed in the current policy?
I would not.
Thank you, my Lord. Let's go to the next issue, which is this, and flows actually from the first part. You do not have to be aware of what we have put in the current strategic plan for my Lord to know, because you have been heading stations, at least 2, Kericho and now Nyeri, to know what administrative gaps we have in the institution. And you, my Lord, if God allows that you be the CJ, you are the person to fill those gaps, with us behind you, of course. But being the team leader, remember, if those of us behind my Lord become two kajuaji, so as I think Kiswahili is part of our national language. We couldn't lead you, you would have to lead us. And then we follow with ideas, we give you our suggestions, which you may or may not accept. So what are those administrative gaps in particular that my Lord would want to see covered, filled, so that we move this institution to the next level?
One, we would require to streamline administrative structures insofar as judicial performance is concerned. What we have now is, for example, in terms of a high court station, is a judge who is presiding, and maybe other judges who are his followers, her followers. In terms of administration, we have everybody in every other sector, HR, ICT, etc., etc. So what we require to factor in is that every sector, firstly, has people who are qualified, people who are experts in that line. What we have now is, for example, in HR, is directorates which are regional. It may be necessary that in the future we have people in every station so that they can be able to address the feelings of the people, the issues of the people in that station. ICT, we have people, particularly now that we are on teams and we will require them. We have people in every station, but sometimes they are not adequate. Like in Nyeri, I see our officer who is at the headquarters, rotating everywhere to
so
go and
the
resolve
first
issues.
one would be to deal with the human resource issues. The next one would be?
Issues of finance. Finance is a very, very critical in performance. We'd have to source funds and facilitate the activities of every other issue or every other matter that we want to partake. The third one would be, like I'm always saying, training of these people, coordinating them. Because one of our biggest issues in the public service, not necessarily even in the judiciary, is that people get disgruntled and you are not working with them. They are there, they come in the morning, they leave in the evening, 3 years, they are away, etc., and nothing happens. So how do you monitor this? I started with saying that we should be able to monitor our people, we should be able to motivate them, we should be able to buy them, buy our staff to our side through incentives which are available, and be friends with our staff. That is the biggest resource. Any other factors, finance included, will not make a difference without an allegiance by our members of staff. And when we achieve that, all these other factors may come into place. So buy your people, put them in place, motivate them, make them happy. When you make them happy, everything will happen. When you involve finance and resources, when you facilitate them, they'll be able to do what they must do. When you train them, when you streamline the governance patterns, like in the case of, I mentioned the case of the chief magistrate, who is the CEO for every station, the magistrate in charge, the judges there with a presiding judge. You create specific roles so that these officers become accountable. Accounting becomes a parameter for performance and for your job and your profession, so that we are able to serve and do Kenya good.
Thank you, my Lord. My Lord, as Chief Justice, would be the chair of the National Council for Law Reporting. What are the functions of the National Council for Law Reporting?
We start with law reporting. It's one of the major functions of the council. The other one is transacting with our judicial officers so that they are on the know by way of information on emerging jurisprudence, the case back system, and other factors like that. When we have a crowd moving a case, it is their duty to broadcast it, to make it known to those who are consumers of that kind of precedent. The law reporting would also be tasked, or is tasked with the duty of streamlining law reporting and doing a highlight insofar as the performance of the judiciary is concerned. You remember we said we send our course list to them for broadcast nationally. So it is their duty. It is their duty about to broadcast the judiciary and our techniques for performance, the DCRT, etc., to the Kenyan public for purposes of accountability. In that reporting, they are highlighting what we are doing. They are highlighting performance. They are highlighting our daily cues, and thereby we move on and get them to work to achieve those desired results.
Thank you, my Lord. Maybe you could tell us where the National Council of Law Reporting is resident. In what institution is the National Council for Law Reporting?
Their residence is at Milimani Law Courts, Milimani Commercial Courts. That is the
under,
one.
sorry, my Lord. Under whom?
It is under the judiciary.
It is?
It is a parastatal within the judiciary.
Let's discuss this because I think it's important. The law reporting, you and I, my Lord, will agree, is an important aspect of the work we do.
No doubt, my Lord.
As we speak today, it is resident in the office of the Attorney General. It used to be resident here, but it moved.
I am not aware of that one.
Which means my Lord would not know the reasons why it moved and whether in fact that movement was right, whether they should stay there or whether the person they serve isn't the Kenyan public through the judiciary of Kenya.
No doubt the National Council for Law Reporting serves the Kenyan public. It is funded by the Kenyan public, and all its issues and concerns pertain to the welfare of Kenya. That being the case, I think the departure from is the most direct link, which is the judiciary of the Republic of Kenya, and which would require it more because of the linkages to the other ministry, the Office of the Attorney General, must have been some administrative measure. It was a government planning, like we said from the beginning. We are complementary. So if there are any issues which relate to this and which the judiciary feels are not in tandem with its good feelings or with its systems, the way out is to renegotiate.
My Lord, to be fair to all of us,
yes,
my Lord confessed that he does not even know where they are resident, and therefore my Lord would not know the reasons why they moved. And I think we shouldn't continue to discuss that in abstract. we would have to get the real reasons to know why exactly it moved, whether that movement wasn't the right thing, because you could disagree with any statement I make or anybody else makes. But let's make progress here. Chief Justice Mutunga was JTF. Chief Justice Maraga was SJT. Chief Justice Marete would be?
Mine would be to practicate judiciary transformation. Why would I do that? We are 9 years down the line. The first one was 2012 to 2016. The other one was 2016 to 2021. That is a cumulative 9 years. We cannot go on transforming forever. We should have transformed. So what happens in the circumstances? I learned in the office of the Chief Justice, and first thing I do an evaluation. I cause an evaluation of how far we've gone in the first compartment, Emeritus Chief Justice Mutunga's JTF, Judiciary Transformation Framework, which was merely, basically laying the background. We come to the one for Emeritus David K. Maraga, and we assess now and get an assessment of how far we are insofar as the judiciary transformation is concerned. When we are through with that report, it will tell us how to get moving. And my take in this one would be, if we are not through with that, with the transformation, the style of JTF, the style of SJT, then we give ourselves strategies to deal with this, but do a practication, because we have this, down. It has been done, it has been started. We now know how the percentage of a transformation that we had. So now, practicate this, make it real. How would I do that? I have talked about two stakeholders, the judiciary staff and the Kenyan public. With those two stakeholders happy, if you make the judiciary staff happy, if you make the Kenyan public happy with you, you've been good stead to practicate. Because that is number one. If you achieve that, everybody who comes through the corridors of the judiciary leaves happy. This is costless.
All right, my lord. Let's go to something else. And it is this. I noticed from your papers that you have a diploma in theology from the PCA University.
Yes.
And now, from that, I ask this question.
Please do.
How do you relate your moral opinions with your judicial philosophy? Would you associate with the legal theories that emphasize an intersection between the law and morality?
I have done my fair share of jurisprudence. How would I relate who I am as a Christian? Because I have many faces. I'm not merely a Christian. I have my other facets and personalities and persons. So the issue is Christianity vis-a-vis what I do. One, I have come to the judiciary. I am an employee of the jails.
I'm glad you are a Christian. You're in good company. I am a Christian. I like to think I'm a fairly good Roman Catholic. But one does not have to be a Christian to do theology. One doesn't have to be. One doesn't have to be a Christian to do a diploma in theology.
Yes.
And so the question is, having done that diploma in theology, how has it prepared you for the work you do? And do you mix theology, religion, morality, and the law?
One, as an officer, like I was saying, I am an employee of the judiciary. Who I am as a Christian is separated from this. Agreed? The School of Law called, the Realist School of Law, says that, states that, opines that a judicial officer would largely, what you see in a judicial officer, or the product of a judicial officer is who he is in terms of personality, in terms of ideology, in terms of thinking. Good enough. That is a legal theory, and we leave it at that. What do we deal with here on a daily basis? You remember my personality, myself, and my Christianity serve me as such. It's a spectrum of my life which is complete and whole. But I must be able to relate this very, very carefully and cautiously with what I do in other spheres of my life, such that when I come to a place like this one where I have to make a decision, it can guide me, no doubt, because even if you are not a Christian, there is some element of religion in everybody, including African traditional religion, which I suspect is almost dead now with 130, 140 years of colonialism and post-colonialism. Africa's culture and the religions are almost dying. So we are saying that we must be able to separate and draw a distinction between the diploma in theology and your religious faith and what you do. You can relate it to some extent, but to the extent that is palatable and acceptable, not anything beyond that. We were not called upon to come to the judiciary to preach, whatsoever not. We were called upon to the judiciary to come and do that which we are assigned, and do it in decency.
Thank you. If you find a lacuna in law, what would my Lord do?
One, before you make a decision and it is broadcasted, there is the issue of a consultation. You discuss to identify whether indeed what you are seeing is the reality. When you find a lacuna and it is established that it is one,
and you are in the middle of a hearing, my Lord, and you must make a decision in that matter, and my Lord encounters what appears to be a lacuna in the law, what would my Lord do?
You address that. At the hearing, if you can, you point it out to the other participants, the litigants, and you look for a middle ground. When you sit down to do your write-up, the ruling or judgment, you would have to point that out. Like I said earlier, this would require consultation amongst your colleagues, so that at the end of the day, you do not, address yourself. You do not clear the lacuna. You do not create your own law and apply it. No. You just note that in the process of hearing, etc., I found out that there is this gap, and you could even point it out to Parliament. It's a stakeholder. I would point it out to Parliament and say, this is what I observe. But when you are very, very clear that what you are doing makes sense, when you've consulted adequately throughout your colleagues and agreed that it is an issue which requires address at any other forum. Yes.
I want us to get to the Supreme Court, but before we get there, Let me just read you this quote from Dawkins, and he says, there can be no gap in the law. The law is more than rules. It is also about non-rule standards, so that my Lord could reflect on that later. But let's get to my Lord's role as the President of the Supreme Court. My Lord arrives in May and finds 5 of us there already, and my Lord comes with one other judge. My Lord has primarily sat as a single judge, primarily. But when my Lord arrives, finds that this court of necessity sees as a multiple judge court. The bench must have at least a minimum of 5. Okay.
Yes.
Is that an easy thing to do? Is sitting in 5 easy?
It is not.
Why is it not
particularly
easy?
for the likes of us who have not even had an occasion to sit as 2 or 3. But the argument is countered by the fact that from day one, 16th of October 1980, when we entered the law school up here, we've had interactions with this kind of situations. We've learned, we know. The only thing is that the only difference is that we've not encountered that. 2, we are equal to the task. We can learn. By the time we leave that evening, I'll pick from yourself, the Deputy Chief Justice, or even before we have a session in court, so that we are able to get educated, we are able to get the exposure, we are able to get
That's fine, my Lord. The question is, because I think this is important, let's just spend another 2 minutes on it.
Please.
Is it easy to sit in a multi-judge bench?
It will not be at any one time because of the issue of diversity. The issue of, like you are asking about, your tentacles insofar as religion is concerned, your ideology, your legal philosophy, etc. That diversity is supposed to be an asset, but can also be a liability, in the sense that...
in fact, stop there. I'm glad you said an asset, because I want us to discuss that other side. Is it not a good thing to sit in a multi-judge bench, because then your idea is strengthened by the weaknesses or strengths of each of your partners on the bench?
It is good. And particularly,
so it's both good and bad?
I am not going to say it is bad. It has all pluses. The only difference and being a liability would come when these people, are not able to agree, and that is allowed. When this disagreement becomes like a part of the problem, and when this disagreement becomes a liability now, or becomes a fetter to the progress of decision making in that court. At all times, this would be an asset, it would be good, there is diversity, there is an exchange of minds, there is, you are able to, interrogate issues and share in a good collegiality. But if this is not the case, if this becomes a problem, if there's no collegiality, if there's no maturity, if there's no tolerance, it becomes a problem. And we can have stalemates, and that will be extremely dangerous. That is not what Kenya has set us here for.
Yeah, but my Lord, it's you who has set yourself up to become Chief Justice. And so you would be telling this commission that even though it is your first time you're going to do this, this is what has prepared you for it, and this is the arsenal. You have to get the 6 of us to work with my Lord the CJ.
Decision making is personal. but we have not even reached there. Day one, we have a matter. When I am new, I will not get to that matter before we have a meeting as the College of Judges in the Supreme Court, so that I am able to learn and know how these things, even the feel itself, that these are the 7 judges of the Court of Appeal, of the Supreme Court. We are sitting together, we are sharing, they are teaching me from the onset so that I become a part and parcel of their team. I would nurture that from the onset so that we don't have any sitting before that is done. And thereafter, we would sit. I would be able to appreciate the issues. I'll be able to relate even more. And in less than no time, in a month, 2 or 3, at most 4, we would be partners in progress, equals in the game.
All right. My final question, my lord.
Please do, and thank you.
What is your most favorite judgment from the Supreme Court, and why is it your most favorite? And I wish you very well, my lord.
I have had occasion to look at the digest which you issued some 2 or 3 years ago, and I looked at those judgments. The other day when I was preparing for this interview, I came across the Marete judgment. Even without looking at all the other matters on elections and references and everything else, let me come to Marete. Marete is a good judgment in the sense that it has brought us to, in tandem with the current constitutional requirements globally. Murder, death sentence, etc., etc. You talked about religion. I mean, at what time should anybody lose their lives? We are saying that we are on a platform of human rights. We are also agreed as judges and the judicial officers. The profession is agreed that more often than not we are making mistakes. So when we do 10 murder cases and hang them, maybe 4 of them could be innocent. Circumstantial things just find them there. etc. So for a long time, the death sentence has not been acceptable. The death sentence has been overtaken by events in other jurisdictions. So when the Supreme Court came up with a decision that that must be done away in this with in this country, I would say that was a ground.
Thank you. So my lord likes Marete because the Supreme Court outlawed the death sentence.
Yes, Marete to us is...
Thank you very much, my lord.
Thank you, my lord.
Thank you, Chair.
I'm so glad that we had that occasion to tete-a-tete over one or two small things.
Brother. Thank you, my brother.
Welcome.
Okay, thank you very much, Your Honor. I will now request Judge Wasame to continue, and the commissioners will restrict ourselves about 30 minutes or less. Thank you.
Okay, thank you, Chair. I'll be brief because my predecessor has almost asked almost all my questions. Judge, I will ask you 4 issues.
Please do, and thank you so much.
Yes, and 2 of them, you are the one who raised them, about the backlog and how you will resolve it. Now that you are applying to become the Chief Justice of the Republic of Kenya, you must be the leader. And there must be evidence in terms of your productivity that you have been a leader in that area. Isn't it?
Yes, sir.
I have a report from the performance and productivity of the Honorable Mr. Justice D.K. Jagi Marete for the period between 2016 to 2021.
We appreciate.
Yes. During that period, my Lord, it says that you handled 3,436 matters. Out of those matters you have handled, you have delivered 73 rulings. Those rulings did not also resolve the cases or close the cases.
Yes.
Again, you delivered 271 judgments. Is that a reflection of Chief Justice Marete?
No, it would be dastardly to have a Chief Justice of that caliber. But I'll go back and answer your question in this manner. In 2018, I was transferred from Kericho. And the ground of my transfer, although it is not stated, was that I had cleared everything that was supposed to clear about the Kericho station. Kericho had a balance of 50 or less files. Eldoret had 800 files. So I made a departure from Kericho to Eldoret and left it judgeless because it would not have been logical to put a judge there. I have my issues on this kind of report. 271 judges in 3 years. I doubt its accuracy because on average, Judge Marete at Kericho he was the sole judge in the station. And on average, Judge Marete would do about 20 judgments. So how would the 20, which is 240 judgments and rulings, on the lower side, how would 20 times 24 times 3 amount to 271 and 73? This is 300 or 350. I doubt that accuracy. Unless there are issues of not transmitting good returns, I'll clearly say with no doubt that is not an accurate report of my performance.
Okay.
And if I do, I would apologize and leave office.
Okay. So if we ask you, for example, to avail your statistics for the period between 2016 to 2021, which is not a reflection of what is before us today, you will be able to do that?
I'll do that with lots of ease. I'll get my dear at Kericho and it will be availed.
Okay. The second issue, my Lord, is an issue which you raised yourself about, you said you are a person living with a disability.
Yes, sir.
Is that correct?
It is correct. I am a person living with disability.
Okay. And before you are granted the certificate by the National Council for Persons with a Disability,
yes,
you must have been assessed.
I was assessed. And I've even been assessed just the other day in a renewal.
And that your request was approved from the minister downwards.
Yes.
And in your application, you indicated the nature of the disability which you are suffering from.
Yes.
Were you given a card?
I have a card.
You have a card?
It is here.
You have it there?
Yes.
I don't know, the card in your file reads, I don't know whether it is true, my Lord, and I apologize if it's not the correct card.
Yes.
It says name DK Njagi Marete. It indicates your registration number, and then it indicates the nature of disability, visual, mental. Is that a reflection of you?
I have a visual disability,
yes,
which has been with me for a long time.
No, I'm asking the second part, my Lord.
No, that I have no mental issues. This was an error. I was warned about it by a colleague who is also, a person living with disability. I have never had time to have it addressed.
And this card was given to you, my Lord, in 2015.
It was issued to me in 2015.
Yes.
I didn't realize that it was an error. I am diabetic.
No, I am not asking about that, my lord. When did you realize that there was a problem in your card, that there was the issue of mental?
I saw it from day one when the card was issued down there.
Yes.
I didn't think it was an issue because when I went to do my application to the director, persons with disability, I cited two issues. One, I have a visual issue. Two, I am diabetic, and occasionally I get affected by what we call low sugar issues, hypoglycemia. So when they looked at it, they dismissed the second issue as a case of disability. And that is where this error came in. From my record, which was in that original application, the issue of hypoglycemia, diabetic versus, oblique hypoglycemia, was taken or was translated to be mental disability, which will never be the case.
Okay, difficult question. I'm not a doctor. Again, my lord, since you joined the judiciary, you have also been having some personal issues with the registrar, with JSC, about your driver.
Yes.
And I have seen a letter from the principal judge of your court saying that the Honorable Mr. Justice B.K. Marete has been having problems with the drivers since 2014. The last one walked away this week. What is the problem with the drivers?
When we came into the judiciary in 2012, I opted to use drivers who were civilian, not police. There is a Mr. Mwangi whom I had employed myself, and I requested that be employed by the judiciary so that he serves me in the absence of a police driver. I am not able to deal with the police drivers in the sense that I have a very rigid schedule. I do not drive because of my health issues and also my choice. I am not a good driver. So I've always preferred that I have a civilian driver who is flexible and who is able to answer to my needs. So what happened is that my driver was employed in 2013 on contract. When I raised an issue on that one, I was told, good enough, we can let us watch him for 1 year. And when we do that, we'll be able to assess whether he's suitable and material for permanent employment or not. 1 year down the line, on 7th of September 2014, when I was going when I was on my way to Kericho, the contract for this driver, Mr. Peter Mwangi Moria, was terminated. Thereafter, I went on a negotiation mission. The CRJ and Chief Justice Motunga, and we agreed that I would restate Mr. Mwangi so that Mwangi would be paid, and then he does refer to me, and he remains and serves me. Mutunga left. That did not happen. I consulted the CRJ, and we had issues, and she told me that what we are going to do is wait for an opportunity and an advert and get Mwangi to apply so that we can formalize that employment. Well, I was not convinced, but that is not my area. I would not order what happens. So Chief Justice Maraga comes in, and the first week or month I go to see him over the same issue, and I do. And we agree with my Justice Maraga, the CRJ, that the CRJ looks into the matter. And all that time, from the 7th of September 2014, I have been paying my driver. In fact, Mwangi ultimately left in fury because I will not go to tell Mwangi that I am doing this matter for you. I'm negotiating with A, B, C, D, and E for you. That is not good, the best of practices. I was quiet. So we were there, and in year 4, he got tired and left. I got other people. Intermittently, police drivers would come in. So one lasted a day, another lasted a week. The best one lasted about 3 months, and they get very impatient and they take off. Reasons I will not be able to tell, but that is my matter with a driver. From 7th of September 2014, going to 6 years now, I have not had a driver who is supplied to me by the judiciary. I have paid my driver.
Okay. The second issue, you have been also having the issue of your personal aid, my lord. Is it a matter of concern to the commission?
It is a matter of concern, but when I become Chief Justice and come to Nairobi, it will not be an issue anymore. Why? My issue of hypoglycemia is an issue, a medical issue, which everybody should pay attention to. I cannot live alone whatsoever. So when you take me to Kericho, we have a home in Nairobi and a home at Chuka. When you take me to Kericho, my spouse must accompany me. When I take any safari or any venture for the judiciary, for my employer, which is out of my station, she must accompany me on grounds which are medical. Thank God we will be Chief Justice in so little time. And when we come to Nairobi, we shall not require any of those issues because we shall be home. The issue was when we served outside Nairobi, we will never serve Chuka. It will not work. So if you send us to Chuka and we are there and you agree that we should be at Chuka, we shall not ask for that. But in a true, it was a justice issue. This lady must follow me. Nobody is taking care of her. She has a hope to take care of. She has her own issues. She has her own interests. Why won't you compensate her as my employer? I am entitled to an aid. The only differential is that this aid is so specialized that she must be my spouse. Did I answer or?
Okay, but you have paid some allowance. Since
the
you joined
disability allowance, which has persons with disability allowance, which is now 20,000 shillings, is not supposed to take care of that kind of things.
Yes.
No.
So
that one is an allowance which takes care of basics. Like if I wanted to take a taxi because of my disability, I would pay for that. If Mwangi was not there or my driver was not there and I'm not able to drive, I could hire a driver, etc. It is not, there's a differential between that allowance, which is payable to everybody who is registered with the council and employed by the government or the judiciary, and the issue of aid. If you are not able to see, we will be able to get you somebody who walks you around to your place of work, to your home, and this person would have to be taken care of by your employer. It is the same situation I have. I am not able to live alone. I require somebody who must live with me. My Nazata will be dead in the next 3 days. So what happens? You are moving them out of their jurisdiction. They are home. So if you do, please take care of that because it's part of the employment contract. That is my argument.
Okay.
And I'm saying very succinctly that if it is a Chuka matter where I have a home, if it is a Nairobi matter where I have a home, I would never touch a cent on that ground.
Okay. So if we appoint you, God willing, my Lord, as Chief Justice, but we don't give you Mangi, your driver, and your personal aide. You will transfer the office of the Chief Justice to Chuka.
I am not saying that is what I'm going to do. What I am saying is that if I'm Chief Justice and in Nairobi, the issue of the aid would evaporate entirely. It would only arise if we are moving out of my station to Nanyuki to check on one or two small things, Kisumu, name it, etc., because she would accompany me and be entitled to that which goes with that. But the aid, the employment status, nothing, because she has nothing to lose.
Okay. And lastly, my Lord, this is a small matter. I've also seen another issue which you have been constantly raising is the issue of the security. And from what I saw, you wanted the judiciary to provide security for your Ngata Rongai home, from again in Nyeri where you are working, maybe in Chuka where you are also reside sometimes. So do you want the judiciary also to provide security for your 3 places of abode? If we, as you are writing also, this is one of the documents I saw, you have been writing about that to the CRJ.
I am not sure of that one, but I remember I wrote on security sometimes around 2016, 2017. What had happened is that when we left for Kericho, we left our boy in the house. At the period of seeking security, the young man decided to go solo. He decided to go to hire a place for himself. So we sought security here, and we were even requested to do quarters for these people, and we did. I cannot remember the precise year. It must have been either 2017 or 2016, most likely 2017. But no security came to assist us at Ongata Rongai. So what I did was my public relations with my boy. And 1 year down the line, the place was vacant entirely. For 1 year, nobody guarded it. I thank God for that, for the security which was, divine. So the young man has gotten back. I would not require any security. If you look at my history, I am not very fanciful of issues of security. I can walk anywhere, even as Chief Justice. I have not offended anybody. I have not taken anything from anybody. If you throw a stone to me, you can only be an aggressor. That's my theory of life. I am very, very simple. Simplicity is a hallmark of my life. I have never requested for any security for Chuka. If anybody tells you that, if it is in my writing, let me look at that. I have never requested any security for Nyeri. I have never requested for any security for Kericho. I have never requested for any security for Eldoret. The few months that I lived there, about 2 years, security is not my fancy. Even as Chief Justice, it will not be an issue to me. You might want to force me into it. The government might want to force me into it, but that one we would have to negotiate. I am not insecure whatsoever.
Thank you very much, Judge, and I wish you well.
Thank you, sir.
Honorable Judge, just a small clarification about the card, because you said you just renewed it. There's a new card now. Is that, am I right?
I do not have a new card.
Or is the same one?
I've never had time to go and, have a renewal of this card.
Okay.
Yes, but I was warned about it by those who are experienced in this game.
Thank you, Honorable Judge. I will now request Commissioner Judge Majaja to take you through some questions also. Judge?
Thank you, Chair. Good morning, my Lord.
Good morning, sir. Good morning, my Lord.
Yes, I'll follow up some of the issues that have been raised by my colleagues who have preceded me. The Honorable, the Deputy Chief Justice quoted to you a quote by Ronald Dawkins, one of the leading jurisprudence, about there being no gaps in the law. I want to just give you a situation, and maybe you'll enlighten us on what you do. A couple, Mary and Peter, let's call them Mary and Peter, are in a relationship. And at some point, the relationship breaks down. Peter, one night, goes into Mary's house and rapes her. Then she conceives. And when she realizes she's pregnant, she goes into a deep depression and decides to have an abortion. At about the same time as Peter is charged with rape, he's leaving the court and he's knocked down by a motor vehicle. And unfortunately, he's paralyzed, neck down. When he hears that Mary wants to have an abortion, he comes before you sitting as a judge to restrain her from having an abortion. Applying constitutional principles under the Bill of Rights, how would you attempt to resolve this issue? Maybe you will tell us briefly.
We have Article 26, the right to life. This one entitles everybody to life. So the attempt by Mary to procure an abortion for the baby or the fetus would be an issue or an obligation, an affront to Article 26, and this would not be a constitutional issue. The right to life is absolute and is an entitlement to every other person. The fetus or the intended baby has that right to life, and therefore should be it should be safeguarded so that we have a natural birth and the baby lives its life. What are the rights of Peter in this matter? Good enough, there was some misunderstanding between Peter and Mary. This is a product of a rape. Does he have any right over that? He does.
And what about the fact that Mary, first of all, she has undergone physical trauma, she has undergone mental trauma as a result of this particular incident, and she says, look, and the doctors have said, if she has this child, she will never be the same. In fact, we will have to take her to Marete. Is that a proper consideration?
It is a proper consideration on medical grounds, on examination or verification by a proper, a qualified medical practitioner. We can the right to abortion is dissipates.
So it is possible that she can have that abortion.
She can have it.
But
if
what about
issues
Peter?
which are threatening her life?
Okay.
And insofar as Peter is concerned, if there's a threat to life, to the life of to the life of Mary, and or a threat to her medical position, which deteriorates this life to.
So if Peter says, Peter is telling you, look, I'm the firstborn in the family. I'm the only son of my father. I cannot have any other children because I'm paralyzed neck down. And let her have this child. I will take care of the child. My parents are willing. Would that change your position?
It would not change my position because these rights must be looked at consecutively. In the sense that, firstly, from the evidence or the facts of the case that you've given us, the most critical person here is Mary. Mary has suffered psychologically on this matter as a consequence of these events. And if we sustain the pregnancy, she might lose so badly that we may not even be able to recognize her. She has a human rights insofar as her life and the enjoyment of it is a concern.
Okay, thank you. Thank you for that answer. I think I'll move on to the next. You have brought us, in your writing samples, you gave us 5 writing samples. One, your dissertation, which I must commend you, under the tutelage of Professor Koth Ogendo.
Thank God.
Yes. Lucky to have been guided by him. Then you have 4 cases and an article. In your dissertation, which is about, it talks about constitutional dispensation in Kenya, the politics of the constitution and the constitution-making process.
Yes.
And I think what we are going through right now is really, this becomes an important topic right now as we are trying to go through the constitution amendment process. And in your paper, you set out 2 hypotheses. The first one is that Kenya is at a crossroads. And you are talking about that particular time. Is at a crossroads.
2005.
Yes, 2005. And you were saying that Kenya is at a crossroads and suffers a constitutional crisis due to past abuse of the constitutional practice by the ruling elite in the entrenchment of parochial self-interests. And 2, the current constitutional crisis is a consequence of lack of legitimacy arising out of reluctance of the ruling class to incorporate participation of the people of Kenya with a view to accommodating their views and interests in the new constitutional dispensation.
Yes, sir.
When you become the Chief Justice, one of the things you may have to deal with is amendments to the constitutions that affect the judiciary. If you are writing this dissertation in reference to what the proposed amendments are to this constitution, what would be your conclusion?
If we are to make amendments to the constitution touching on the judiciary, our constitution is very, very clear. The issue of public participation must be heard before laws, policies, etc., are heard in this country. And it is basically a right that we include everybody in the decision making and in our policies and in the way we run government. So if we would have to have constitutional amendments which touch on the judiciary, then the judiciary must be involved. Kenya in entirety must be involved because primarily the judiciary is the property of Kenya. If we are not involved, if Kenya is not involved, we are as a most immediate stakeholder with the people of Kenya, then it becomes unconstitutional, and we would put a case against those who are in charge of the process.
What I want you, my lord,
please,
is you have come in and now you have found the amendment in place.
Yes, sir.
You are part of the KMJA, and we have made our position very clear.
Yes, sir.
We think that these amendments are an affront to the independence of the judiciary. in your first address to the judges, to the magistrates, and to the public, given those amendments, what would you tell the public?
I would tell the public that, one, the staff of the judiciary are not happy with the proposed amendments to the Constitution.
No, they've already taken place. You are now Chief Justice. The amendments are here. How are you assuring us, the JSC, the judiciary, the public, that in fact we are independent?
I'll assure my members of staff and the JSC, because I'll be the chair of the JSC, that we shall take immediate steps to renegotiate the amendments which relate to the judiciary. Because if the amendments are there and it is like final, we cannot close that. Conciliation does not end. We'd have to, if they are not there, if they are offensive to our functions, we will not close there. We will not say that that is enough. We will not say that we are beaten.
Okay.
We would still push it and raise it. If we get to a deadlock and they are not, it is not done, we leave it at that. We are not going to fist cuff.
Okay, thank you very much for the answer. One of the important areas you will deal with as President of the Supreme Court is the presidential election petition. And I'm sure as you came through this interview process, you familiarized yourself with the jurisprudence, the decisions.
Yes, sir.
And there is a decision that came from the East Africa Court of Justice, Martha Wangari Karua versus Attorney General. You are aware of it?
I have, I know it from the general public, the press.
Have you read it?
I have not read it.
Have you read the cases that led to that decision?
I have not. I relied on the material which was distributed to us some 2-3 years ago, the 2013 elections.
So have you read about the election petitions, the issues about jurisdiction?
Yes, I have, sufficiently.
Sufficiently?
Yes.
So the proposed amendment intends to make the Court of Appeal the final court in respect of election petitions. In your view, is that a good thing or a bad thing?
That is a very, very good thing. I have been through some write-ups by people outside the judiciary and even inside the judiciary. I've read your write-up on that book on elections. I've read Chief Justice Maraga's. I've almost virtually gone through that book. And issues are arising on the jurisdiction of the Supreme Court insofar as election petitions are concerned.
So what is the issue about right now in terms of the jurisdiction of the Supreme Court in election petition? Where does this jurisdiction come from?
The jurisdiction of the Supreme Court in this matter, in the matter of elections, arises out of Article 163(4), where the issue of interpretation and application of the Constitution comes in, and the alternative issue, which.
So what is the? Yes, they said that it's an issue of interpretation and application. But what do the critics say about that approach?
The critics are saying this, and they have raised 4 points. Muthomi Thiankoru, who was involved in the Munya 1 and 2 cases, has written a very beautiful article.
Yes, so what are these points? Just tell us the
points. He says, one, there are amendments to the Constitution, I mean, to laws, 2013 amendments did not touch on the Supreme Court. The amendments which touched on elections in 2013 to the law were for the High Court and the Court of Appeal. That's a first pointer that the Parliament did not have any issues, did not envisage a situation that, would not have wanted a situation that the Supreme Court becomes an arbiter in election petitions. That is the first pointer. The second one is the capacity of the Supreme Court. There are 7 judges. We have 67 senators, 47 governors. We have 390 MPs, 1459 MCAs. Would any sensible Parliament have anticipated that or provided that in the Constitution, so not the Parliament, but the constitution drafters, would they have anticipated a situation that the Supreme Court is able to deal with any leftovers, because leftovers are the appeals over these matters, and deal with it?
The third point? The third point?
The third one is decisions of the Supreme Court itself before 2013. The decisions of the Supreme Court pre-election pointed out that this is a memento court, which only comes out at moments of constitutional interpretation, or they call it a constitutional moment. That is when we rise up and answer to this. So if that be the case, then why would it have to shift immediately after the election, so that every other matter which is in the Court of Appeal, etc., would have to get to the Supreme Court? And lastly, Mudhomi Diankolo argues that any looking at the Constitution of Kenya 2010 does not indicate, there's no indication whatsoever that it intended that the Supreme Court becomes a final appellate court in election petitions. If you read the Constitution.
So, if the amendment does not go through, what position would you take?
As the President of the Supreme Court of Kenya, as the Chief Justice of the Republic of Kenya, this is an issue of public controversy. The jurisdiction of the Supreme Court, and particularly relating to election petitions. What would I do? Firstly, call our people, I mean the Supreme Court itself.
Let's put it this way, because you don't discuss, you don't decide cases outside live cases.
Yes.
The court has said we have jurisdiction.
Yes.
What is the reverse point? You would say, if you decide that the court has no jurisdiction, in what instances then would matters of elections come to the court? Because you can say, if the court had not said, elections petitions do not have matters of interpretation and application of the Constitution, in what other way would election petitions reach the Supreme Court?
In my own thinking, supposition, and from what I've read, firstly, I would consult widely, particularly amongst the judges of the Supreme Court, so that we come up with our position on the matter. After coming up with our position on the matter, we would go to other stakeholders, those who bring in these arguments and thrash it out, so that we come up with a concrete position which would act. I am warned that I would not go and bulldoze the judges of the Supreme Court into any position insofar as
yes,
the matter.
It is true you would not bulldoze anyone, but now we are having a discussion. Say, before you come in, the court says an election petition is not a matter of interpretation and application. In what other way would an election petition come to the Supreme Court other than application and interpretation of the Constitution?
I would be very, very, very vague at personal level.
No, not at personal level. You are the judge.
I'm the Chief Justice.
Yes.
We have the judges sitting and deciding on what to allow in and what not to allow in.
Yes.
Precisely that. In that kind of a circumstance, we would have to scrutinize the matters for constitutionality, because it has been argued that if you wanted to raise this matter and enlarge it, every other activities of our lives are constitutional matters.
Okay, I will leave that for you to digest.
Thank you.
The next point I want to take you through is what my colleague Commissioner Warsame touched on. He talks about your driver. He raised the issue about your drivers. You have explained it. But there's another concern which there is a case here. First of all, you are the Teachers Service Commission.
Yes, 5 years and 70 days.
5 years and 70 days. And you were relieved of your duties there.
Yes.
And you went to court.
I did.
And the court vindicated your
all the time.
Yes, vindicated your position. So, in one of your judgments, this is the case of Professor Misia Manoguti Kadenyi and Masai Mara.
Yeah, the Masai Mara University case.
And this is, it's not anything to do with what you did. It's just I want to put to your situation, which, in that decision, and this is what you said. On this, I wish to rely and take credence on the authority of D.K. Njagi Marete versus Teacher Service Commission, 2013 KLR, where my good friend and brother, Rika J., very ably interrogated this term, and you were talking about termination and retirement, and came out as follows, and then he stated the law.
True.
Now, as a judge, wouldn't this kind of statement worry you that this is, you're quoting your own case?
One.
Two, you're saying, my good friend and brother, Rika J., a case which you succeeded. Wouldn't that worry you?
Good enough. It's a question of expression. One, when I quoted the matter because throughout our jurisprudence in the court, in the last 8 years, or any other jurisprudence, I have never had occasion to find anybody who had that succinct and a very good definition of what retirement on public interest is.
Okay.
So it's a matter which fascinated me. In fact, I would give him 1,000%, not 90 or 100. 1,000%. It was beautiful and nice. Okay. On the other issue, we were here in 2011 and 2012, and I learned from the JESC then when we came for the interviews for appointment, the issue of language and talking softly, and I can't remember the term they use. Is it a hard language? I can't remember. But whatever it is.
Yes.
One, I am a student of literature, and I believe in expression.
Yes. The point is, before we go on, the point is, if the Teacher Service Commission were reading this judgment,
yes,
okay, you fought them in court.
Correct.
Now you are referring to the judge as my good friend and brother. What is the perception they would have?
One, a good friend. There is no possibility. You know, you are my very good friend, good commissioner. We work together. We are in the same station. We are in the same court, the High Court and the Equal State. We are in the same. We are equals. We interrogate when we find occasion, like in the colloquiums, or when we meet in the streets, or in the corridors of the court, etc., etc. I have no enemies whatsoever.
No, the point I'm making is not that you have no enemies, you have friends. But you know, for a third party, this is Teacher Service Commission, they have been in litigation with you, then in a judgment, you're quoting, you say, "Judge, my good friend and brother." Don't you think that's an issue which you ought to reflect on?
It could be an issue
yes.
if you are a simpleton. This is the English we are speaking, not the language of the people of Chuka. Even in the language of the people of Chuka, it will be the same. We are saying, I have done some descriptive, a reference to, that's what I feel about him.
Okay.
It has nothing whatsoever to do with what he gave me. In that judgment, he clearly tells everybody, the whole world, that in that period that he was dealing with the matter, none of us, Judge Onyango, the principal judge, was the prosecutor. He prosecuted that matter for the...
Okay, thank you for that explanation. I'm satisfied. So I'll just go back to the last issue. In your earlier discussion, and you laid a lot of emphasis on that, you talked about, you really emphasized your relationship with staff, making staff happy, motivated, and being friendly. In this case of Collins Odumba, it was a case for contempt, isn't it?
Yes.
And the accused there was a member of staff.
No doubt.
Was a member of staff.
Yes.
Now, one of the complaints I have had, and this has been mentioned to me, is that the staff accuse you of being high-handed and heavy-handed. High-handed and heavy-handed. So this was a case where, and if I may just read for you, you say, on the morning of 27th, we were treated to a now commonplace spectacle during proceedings in court. In the middle of the first phase, there were loud, continuous noises heard from outside the courtroom. It was clear that this was a chat between two persons, and the volume and continuity of that noise forced the court to stop its proceedings, as this was not possible or practical. So there was noise in the court, isn't it?
Yes,
and
on the corridors.
On the corridors, and you were unable to proceed.
Correct.
You then went and inquired, who is this making noise? Sent your clerk, find this person.
Bring him in.
Bring him in. Okay. A lot of things happened between, and he was finally charged with contempt. In fact, you said on 30th, this was on 27th, you realized the accused on 30th, this is from your own writing, on 30th May 2016, the accused, who I now realized was a court staff or officer, was brought to court at around 11 hours. 100. What I want to ask you is this. We know contempt is a very serious issue.
No doubt.
Yes. And in fact, you recognize that in your decision.
Yes.
But this is a member of staff.
Yes.
Is a member of staff.
Yes.
Surely, weren't there mechanisms within that station you could use to deal with this particular issue?
If you read the ruling, clearly, you'll appreciate that this was not a one-day matter. This matter had continued for well over 6 months. We addressed issues of people making noise in the corridors, day in, day out, etc., etc., etc. And we had even the chief magistrate, now Judge Ongondo, had taken steps, plus my dear Mr. Ndoruri, had taken steps to fight this menace, but it would not go away. For a long, long time, we have this issue, and it is not going away. For a long, long time, we have, the cells down there, and there's noise, and it is refusing to go away. We cannot sustain this. So on this day, On this day, we heard the noise. People are chatting in the corridors, and the court is continuing, and we call for the officer. We call for the persons who are making the noise. One is brought in. In fact, there were two members of staff. One is brought in. The other one says nothing. I am not heeding to that call. What choices did we have? What I did was stop the court and defer proceedings and deal with the matter. How did I deal with it? I got the person arrested and brought it to court. When he was brought to court, he was so panicky, etc., and I said, put him in. We have no time. We can deal with him on a different date, on a Monday. We resumed the court.
Okay.
That is the circumstances under which we dealt with that matter.
Okay.
The nuisance had been continuous for a long time, and we suspected that it could even have been deliberate and political. Okay. Otherwise, how are we able to deal with noise day in, day out, 1 week, 2 weeks, 3 weeks, etc.?
In fact,
those are the circumstances in which we found ourselves, and we had to be firm. High-heartedness and firmness are two different things. I have never boxed any of my officers. In fact, my officers are very, very happy with me. Where you get this kind of reports, good commissioner, I would not know. But when you get that kind of report in the future, even when I am Chief Justice, get that person.
So at the end of the day, would you now you're the Chief Justice tomorrow? Maybe you're the Chief Justice tomorrow. Are you telling staff that in fact the criminal law will be brought to bear to them for any infraction? That they should fear you because you're the Chief Justice who resorts to the criminal law in order to resolve problems in administration. Is that something you want to tell them, to reassure them?
That is not the message. This was an exceptional case and a last resort. If we had not taken that kind of step, administration had been there. We have a DR, we have a chief magistrate,
in fact,
we have a presiding judge, and this issue had been, they had handled these matters, and they were not coming to there was no solution. Particularly when the officer one officer comes to court and sits there with us so that we interrogate the issue of noise.
Okay,
the other one doesn't, that refuses flatly. Yes. How would you deal with that?
In fact, in your judgment, you say this issue has variously this is your own words, reported to the judicial officer in charge of the station, but to no avail. So you had reported to the station.
Yes.
And you even asked, who is in charge here? The Chief Administrative Officer, Rate CEO of Judicial Law Courts, is the Senior Principal Magistrate, one George Ongondo, that is now our colleague in the Superior Court. What tale of expedient court administration does this portray? What are our levels of leadership in this sector? One thing I want to ask you, were you a member of the LMT in Kericho?
I was.
You were. Was this issue raised?
It died with the prosecution or the litigation of that matter.
No, prior to the prosecution, was it raised?
It never featured as a matter for discussion in the LMT.
Yes, it never. So you were aggrieved many times that this is an issue of noise. You attended the LMT, never raised it. Thought it was serious enough, started contempt proceedings before yourself, and then in your own judgment, you indict the leadership of Kericho. So what I'm just asking, should the staff, judicial officers, heads of station have faith in you as the leader to lead this judiciary?
My answer is loud and very, very clear. Everybody is entitled to their feelings on any matter. we cannot take away that right. It is indivisible and a human right. The staff of the judiciary would have to have their own assessment, have their own feelings about me, etc., etc., etc. I have my position, and I will assure you, Commissioner and my Lord, that we cannot lead without firmness. You will not get anywhere. You will not get any results. You have to be firm in what you do so as to be able to establish, to get results, to establish your policy, to establish your work ethics, your standards.
Okay, thank you very much, my Lord, and wish you well.
Thank you.
Okay, thank you very much, Honorable Judge. We will have a short break. But before we do that, Honorable Judge, we must observe the constitutional requirement regarding diversity, so which is your county. Is it Meru?
No, I'm not from Meru. I never was from Meru. In that great Meru, we were just sojourners.
Okay.
And peripheral.
All right.
I come from Tharaka Nithi.
Tharaka Nithi?
Yes.
Thank you. And ethnicity, Judge?
I am Chuka.
Chuka.
Yes.
Thank you very much. And then there's a request, Your Honor, that the card that you have, we would like to see it, just to compare it with the card with Judge Wasame, so the CRJ will pick it from you, Your Honor. And you have 10 minutes break. We come back at 11:20.
Thank you. Good chair.
Thank you. So, Commissioners, we can take a break for 10 minutes. Okay.
Thank you.
So we are now going to go to Commissioner Macharia Jero for you to ask your questions, Commissioner.
Okay, thank you, Chair. My Lord, thank you. Now, I'll take not more than 30 minutes with you. And I'll start with the sample writings, my Lord, that you provided.
Yes, sir.
Now, you are referred by my colleague, Commissioner Majanja, about this case of Professor Misia Manuguti Kadenyi.
Yes.
I'll come to that later. But there was a similar case that you had decided, which you provided a sample writing. The one relating to Samson Olekisir Koi.
They are cousins.
Was Masai Mara University.
Yes.
Now, and what I noted in the same case, of course, you also made reference to your personal case, where you also referred to your colleague judge as my friend and brother. I'll come to that later.
Please do.
But when it came to the kind of awards that you made, I couldn't follow, and I'm asking this because I need to understand your jurisprudential leadership if you become the Honorable Chief Justice. Because one of the things that you did is that this was I think he must have been the Deputy Registrar Administration in the university.
Yes.
Now, who had been terminated.
Yes, sir.
Now, you started by saying, of course, you reinstated him, you ordered that he be reinstated. But one of the things that I found I couldn't understand, but you could explain to me, is that the date when you issued the judgment, you said that I hereby order that the petitioner reports back to work tomorrow, the 1st February 2018 at 8:00 hours. You know, basically
yes.
saying tomorrow by 8.
I appreciate.
You're back in the office.
Yes.
Now, which I was wondering that whereas of course you'd be entitled to grant that kind of an order, whether as a judge you don't see any practical difficulties in that, in not granting at least some reasonable time even as you are granting these rights, balancing it with some reasonableness. Because you'd imagine if somebody has been away for over 2 years, you know, the employer would even require probably to put in a desk, arrange some administration some administrative measures to make it practical for this order to be effected. What could inform your decision to be so drastic as not to even grant that reasonable time?
I don't know whether you want a very direct question. I can give you a background.
Yeah, but not too long. That in the interest of time. But you have your day. That's all right.
Yes, I have accused myself of being the judge in that court who is all too free on reinstatement. Having said that, and with my issue in my reasoning in mind, that employment in Kenya is like a matter of life and death. Whenever you can get back to work, please get back to work. Two, the immediate date. In this case, we have established a case of unlawful termination of employment. That is ugly enough. You've been out of work for so long. Another very ugly situation. You've gotten judgment in your favor. The practicability of, giving you time to return to work, to me, would not make a lot of sense. Because the employer is there, he has offended you, he has transgressed your rights, he has made you suffer for no good reason. What is this so critical situation, which would be worse than what you have suffered, that would require that we give you 2 months to resume work, etc., etc. I have never thought that it is impractical. I've always thought that it is immediate, and that is what I have done in all my cases of reinstatement. I have never considered that I am being offensive to the employer. If the employer finds that he is not ready or etc., etc., I have returned your employee. Deal with the situation. That is a domestic matter. The judge has done his work. And to me, that makes a lot of sense. If I am faulted by other quarters, I am agreeable.
Then in the same decision, you went ahead and said the respondent be and is hereby ordered to meet and pay the respondent's salaries and allowances owing but unpaid during his suspension, which is all right. So basically you're compensating the petitioner for the time that you found that the termination was unlawful. So you are reinstating them, kind of like putting them back to the same position they were before termination.
Yes,
but which is fine. But my problem again now, which I couldn't understand, of course I'm not the judge here, just need to understand your reasoning. You go ahead again and say you're also awarding 6 months' salary as compensation for unlawful termination of employment. So you are not only giving the salary during that time, plus all the allowances, you are reinstating them to that position, but you're also adding another burden of another compensation on top of the compensation you've already awarded. So, I mean, I'm not really getting, what is the reasoning behind that and the fairness in it, the justice in the matter. Could you kindly just expound on the jurisprudence behind that?
The issue of the 12 months compensation, which must not necessarily be 12 months. 12 months is the limit. You could do a month, you could do half a month, you could do 3, 4, 5, 6, etc., etc. And Section 49, 1C of the Employment Act is not in entirety the total compensation available to a case of unlawful termination of employment. The judge has the discretion to look for other remedies which are available and which have been prayed for to offer. And this will depend on the circumstances of the case. The judge exercises the discretion depending on the circumstances of the case. By the time you do the matter and finalize, you've gotten the gist of the matter, you've gotten the involvement of the parties, etc., etc. That is what dictates what you offer the aggrieved party. And in the circumstances of that case, we are compensating unlawful termination differently from any other issues of compensation that may have arisen in the circumstances.
Yeah, that's all right.
That is
Judge,
allowed.
Yeah, Judge, but it's only that again the discretion must be exercised, should not be exercised whimsically. And again, you see, you already compensate the person. But I don't want to make it an argument, I just need to understand your jurisprudence. But now, you've reinstated the person, which is fine. You've said they be paid all their salaries and allowances, which again is fine, I don't have an issue with that. But now again, you are saying, a permanent injunction be and is hereby issued restraining the respondents from commencing any process towards replacement of or replacing the petitioner in the position of Deputy Registrar Administration. Now, if they're already back in the position and you've compensated them, but you are saying that there should, basically what you essentially you are saying is that there should not be any process towards replacement. So if this person misbehaves again, you know, it means then that the hands of the employer are tied, they can never start any process. So again, what is the reasoning around that?
Thank you, good counsel and Commissioner. I relied on the historicis of that matter, the background and the data available, the evidence in the matter. What did I hear? What did I know? etc. The environment was so hostile that we had to safeguard the position of the employee when he goes back to work for various reasons which are very clear, that that was a very hostile affair. And two, the issues which they were fighting were not issues which were industrial. All evidence will tell you that it is personal. So when it is personal and you can see it so clearly, you may not be able to declare it or say it, etc. What you do is issue as much safeguards as are possible to the employee. The employee and the employer are not equal. This is an interplay of labor and capital. Capital is always superior. So you safeguard safeguard labor depending on the circumstances. You safeguard the capital, or you remedy their situation depending on the circumstances. In that, under those circumstances, and knowing the matter the way I did, I was convinced that that gentleman required, the claimant required security in his employment.
Yeah, but you see, Honorable Judge, when you are telling an employer that you should never touch this person for as long as they're an employee again.
Oh, thank you.
Basically, you're tying. But let's move to the next.
I could answer that very briefly.
Yeah, please go ahead, Judge.
You choose.
Yeah, please go ahead, Honorable Judge.
That was not permanent in that sense. In fact, when he resumed employment on day 3, if he missed, they would restart the process. That was supposed to deal with that situation, the situation we were adjudicating, not anymore.
Yeah, but you see, the way your order was framed had the opposite effect. That's the problem I have, and that's why because I'm asking you jurisprudential questions, because you'll be the leader of jurisprudence in the institution. So that's why I'm asking that question. But now, let's test your decisions, because I had to again now do a bit of research, because this matter of Professor Misia Mangut Kadenyi, the one you asked by my honorable colleague. Now I went ahead and actually noted that it's a matter that was a subject now of the Court of Appeal. It didn't end just with your court. And now what I noted is that, for instance, the award that you had given in this Professor Kadenyi case, apparently what you had done is that you had awarded compensation, you had picked a salary, which you awarded against the employer, which was not supported by any evidence at all. The evidence was based on the evidence that had been given to you was showing a monthly salary of 333,640, but you picked instead 658,112. You know, in fact, the court said, we have carefully gone through the judgment of the trial court, and there's no indication at all where the monthly salary of Kenya shilling 658 to 112 is taken from. There is therefore merit in the submission by the appellants that this figure is unsupported by the evidence, and we therefore set aside the learned judge finding the monthly salary of 658 to 112 and substitute therefore with a monthly salary of Kenya shillings 333, 640. So you can see a problem whereby you are probably making a decision based on other considerations, probably emotions, and I can see you keep, in all these decisions, you keep quoting your personal case against TSC, which again in this case, you are being accused even by the appellant saying that you seem to be relying more on your personal experience with the National Teacher Service Commission, and there seems to be anger and, which is because of probably you are feeling that you are mistreated, you are now transferring it when you are now deciding decisions. So, I mean, wouldn't you consider this to be a serious indictment even by the Court of Appeals regarding how you are making decisions of a mandatory nature against employers and supported by evidence? I don't know what would be your consideration to that, Honorable Judge.
On the first issue, the issue of the amount which was multiplied as a compensatory figure, the 629. Section 49(1)(c) of the Employment Act covers that. Section 49(1)(c) talks about gross salary, not net salary. The employment law does not know net salary, because when we are compensating you for unlawful termination of employment, we go by the law, and the law provides that we use the gross salary. So what a judge on finding of a situation of unlawful termination of employment would look for on the pleadings is all the itemization of dues. I was paid 4,000 shillings as a basic salary. I was paid 1,000 shillings as a house allowance. I was paid 500 shillings for transport allowance. That is what you add up, and that is what I did to get to a figure of 629, including the car allowance, which was, if I remember right, 129,000 shillings. So you add all that, you must accumulate all that to get what we call the gross salary. And that is what now, in your discretion, 1 month, 2 months, 12 months, 10, blah, blah, etc., etc., you use as a multiplier effect to get the figure. The Court of Appeal, we may not be able to correlate it. It binds us insofar as that matter is concerned.
Yeah.
But going back to, to ourselves, we would always want to ask ourselves, which is the earlier? Is it the Court of Appeal and its findings in the professor's matter, or Kisirkoi's matter, or the Employment Act? A big question.
Yeah,
I have answered your questions. If I haven't, I could
well,
continue.
The principles of stare decisis bind you. This is the Court of Appeal. Now, again, then, my Lord, again, you see, in Samson or like Kisirko, you made that order that the employee reports the following day. And what I noted is that in, again, Professor Misia Kadenyi's case, you did the same thing. Ordered that, report tomorrow. So in the Court of Appeal, this is what they had to say about that issue. We wish to state that in instances where the court is satisfied that an order of reinstatement is deserved, it is not prudent to direct that a claimant reports back to office within a day from the date of a court decision. Such a drastic order is likely to present considerable implementation challenges to an employer. In our view, a reasonable period, depending on the circumstance of each case, ought to be given for the reinstatement to be effected. So you can see when the Court of Appeal is saying that is too drastic, there has to be reasonableness. And you see, the reason why I'm asking this is because you'll be our Chief Justice if you become one. Now, the issue of reasonableness now starts arising in your decision-making process. I don't know whether that makes you change your mind regarding those kind of drastic order that you keep making, that, I'm issuing an order, I want it implemented immediately without considering the the challenges that would arise from the implementation, not just in the decisions, but even in your day-to-day decisions that you could make here as our Chief Justice?
Well, thank you, good Commissioner. We are open to learning. That is one, first and foremost. But like I said earlier, that is what I have practiced throughout my career, 10 to 9 years in that court. Nobody has raised an issue on that in the past. The matter you are referring to was not an ordinary matter. There were other, side issues relating to the matter. As the Chief Justice, we would not like to do anything which hurts anybody, even as judges of the employment court. I would never have imagined that when I tell somebody to go back to work the following day, there would be an issue, because employment is contracted. The employer could go back the following day and is given a week's leave. In any event, he's been away for so long. The employer could go back the following day, and then another different arrangement is made. All those factors come into my mind when I said that. The agency I created not because I want to make it impossible for anybody, not because I want to punish anybody. I want to it's an indication of agency. It's an indication of seriousness insofar as labor relations is concerned at the workplace. I am telling everybody that good enough, you are secure when you harmonize your relationship with your employees. When you don't do that and you deal A, B, C, and D, what we shall do is we shall tell them to return. And not because we want to be offensive, but because it is their right. But primarily, I think the whole matter is open to the employer and the employee to deal with that aspect. And if we don't have impossible situations, because we are human, when it becomes an impossible situation, there's no employee who takes charge of an industry. So if he's told by the employer now, you can come back in 2 weeks, 3 weeks, etc., that would be okay. That would be good practice. You will not insist that it just sticks there and it stays there, and bears the fruits of immediate reinstatement.
Okay, Honorable Judge, just 2 more points on that decision.
Please.
That we move to something else.
Yeah.
Again, you see the same decision of a Prof. Now, the evidence was very clear that the position of Deputy Vice Chancellor, Academic Research and Student Affairs had already been abolished. But that notwithstanding, you still went ahead and said that I'm reinstating you to this position. Now, again, I'm not able to understand why you would insist on reinstating somebody to a position that no longer exists. And in fact, to that effect, the Court of Appeal again said, considering that the position to which the respondent had been appointed had been abolished, we think that it was not appropriate case to order reinstatement. Balancing the interests of the parties tilted in favor of not ordering the reinstatement, we therefore allow this ground of appeal. So why would they take for the Court of Appeal to be the one now to see that it doesn't make any practical sense at all to order reinstatement of somebody to a position that does not exist? So again, I'm not understanding the reasoning, around that.
If you get to the background of the matter, you appreciate that that was not a matter industrial relations. The issue was not industrial relations. The issue was personality. You versus somebody else. The Vice Chancellor versus her deputy, etc. And it was not even more personal. It was strictly a personal matter.
Yeah, but
so when it comes to me, and I take that evidence, you say that the place, the position has been abolished. That is your evidence. The other one says that no, the position is not abolished, and if it is, it was not done in good faith. So where does that leave us? When we get a situation like that one, we have a over-insistment in that kind of circumstances. We have the most obvious choice. That one of getting back to a position similar to, getting reinstated to a position similar to what you have. But looking at the historicity of that matter, I thought that we should not encourage personalization of industrial relations, of employment issues or employment contracts. Let her return to that office in the same position. The balance belongs to them. The Court of Appeal, I think,
I agree with you, but you have to always remember that you have to remain a judge based on the evidence, the facts, the law. And you see, this is a case where there was an opportunity for either reinstating to that position or the position of the professor to continue teaching. You reinstated both. The first one was okay, even the Court of Appeal agreed that the one of the professor, that's fine. But this other position, because teaching is always teaching, so you can't say you've abolished teaching, so that's fine. But you reinstate someone to a position that does not exist. I mean, don't you think then that you're putting, the employer in a situation that they can't actually be able to comply, making orders that are in vain,
I am saying that there was evidence wholly on the situation on the ground. There was evidence to the extent that this matter was not so much employment or industrial relations. It was a matter which was, personal. The Vice Chancellor and the Deputy Vice Chancellor.
Okay.
ETC, ETC.
Yeah.
And that is why I dealt with it that way.
All right, we leave it at that.
The Court of Appeal has come its own style.
Yeah.
It has taught us one or two things.
Yeah.
I had other options, which I chose not to take for various reasons. I get it.
Yeah. Then this issue of keeping on quoting your case was also submitted on, extensively. It was found to be, whereas it's a matter of your choice, but not tidy, as was also observed in a passing. But now let's leave the cases now. Let's discuss now you as an individual, so that if you come here with us, be with us, we can see whether you can be able to do the job. Now, you asked about the question of collegiality in the Supreme Court, where it would be now the president of the Supreme Court. I would want to understand, like, for instance, if the disagreement among the judges there, and you be now their president, and I'm talking about disagreement, not about personal disagreements. I'm talking about disagreements on decisions. Now, I would want to understand, again, not in so many words, how you'd want to, which way you'd want to go in terms of managing it. And I'm asking this because, not because of our Supreme Court, because I took interest in some matter in the Supreme Court of US, Small versus Memphis, live gas and water, that is the case, where the Supreme Court declined to take over to take an appeal which sought to review a famous case of 1977, which would have reversed a precedent that had been established in the US. But two of the judges disagreed, with the refusal by the other judges, specifically Neil Gorsuch and Samuel Alito. And they actually went public, wrote, a decision totally disagreeing with their colleagues and all that, and went public. And of course, the other judges were quite unhappy with that kind of with that line of action. How do you deal with a situation like that, and what would be your preference in managing a situation like that?
This is an experience I may not have. It's an experience I am going into immediately when I become a Chief Justice of the Republic of Kenya. So how do you manage that? At our induction course many years ago at the JTI, we were taught elaborately the subject of collegiality by one of the commissioners here, the Honorable Attorney General of the Republic of Kenya. And this simply means creating brotherhood. Judges are limited in decision making. I mean, there's independence in the decision making. But my understanding of collective decisions, like the ones of the, big bench decisions, is that these are negotiated. There is a conference, there's a conferencing, and after conferencing, they get to level 1, maybe level 2, agree, and if there are any dissents, the dissents also take their place. So, in the circumstances of that kind of situation, however hard the matter is, the judges of the Supreme Court have a duty to deliver justice or to make determinations in all matters, regardless of the intensity or difficulty. We cannot just come out and resign and tell Kenya, no, this one is beyond ourselves. So you say to them.
Okay, so you'd agree with me that experience in managing, even a bench. You said you've never been in a situation whereby you've sat even with colleagues in one bench. I think that's what you said, that also is it's necessary to have that kind of experience, which probably
When we get to the Court of Appeals, to the Supreme Court, I'll be one among its equals.
All right.
There are many judges there who have vast experience in these matters, vast experience at the Court of Appeals, vast experience at the High Court. So there's nothing we lack. It's just a question of teamwork. You can, get off the chair over the Supreme Court in a session where we are doing the conference and hand over to somebody else who takes charge and guides everybody and leads and teaches. In fact, a colloquium is an issue of teaching, exchanging ideas. Sorry, not a colloquium, but a conference. Is a teaching and exchanging and sharing differential, merging differential, etc., so that you are able to create a consensus. And that is where we are. The issue of being Chief Justice and Chairman is just peripheral. This is a team of equals. And we must always recognize that there are two types of seniority, insofar as the legal profession is concerned. The seniority based on the date of admission to the role of advocates, seniority based on the date of appointment as a judge, the date of entering that role. So those must be taken into account. But overall, knowledge, expertise, experience, goodness, cleverness, and what have you are not an issue of possession. They are an issue of knowledge. Knowledge is basically knowledge. You know or you don't.
My Lord, I was referring to the experience.
Honorable Judge, maybe you can be addressing the commissioner asking the question with respect. It's good to address the commissioner asking the question first.
I was referring to the experience. You see, the High Court judges, sometimes you find that a bench has been impaneled, so they manage that. Same thing also in the Court of Appeal, of course, they deal with benches, and Supreme Court also they sit, and many of them. That's what I was referring to. But again, I'm wondering. You said that when you were asked one of the questions, I think it's when you were asked about leadership, and you said that you've not sat in any big office, and you actually talked about having risen up to, I think, senior state counsel. And then you referred to being a senior, I think, legal officer or something at the TSC. Then you became a judge in industrial court. Now, so I'm wondering, if we give you again this position of the Chief Justice, which is quite senior, where you are responsible for for a lot of resources, a lot of issues, it's an arm of government with many responsibilities. Now, I don't know what you do to convince me that the learning curve wouldn't be a challenge, because we can't take chances. It's a position. You see, there's a position that there's also very high expectations from Kenyans, the members of the public. Now, I'm just wondering, as Judicial Service Commission, how would I, for instance, as a commissioner, account to Kenyans that I've given to my lord yet, you know, the burden of proof on his part that he is equal to capacity, not based on what he's telling me that he'll do, but based on his past, you know, that he can do to prove that he's equal to the task. How would I be able to account to Kenyans? I'm asking this with tremendous respect, not to demean what you've done before, but I'm just saying responsibilities versus what you've done and the office. How do you convince me so that I can be able to give you marks with that in mind?
In the first parliament, 1963, when we got independence, most of our cabinet ministers were less than 30. They were politicians. We had not been, we had not ruled ourselves whatsoever, but we walked through. Mzee Jomo Kenyatta was a president. He has not been a president whatsoever. He was just an activist, a politician, a freedom fighter, but we walked through. What we are saying is that to gauge what I'm capable of doing as a Chief Justice, look at what I did in Sharia House in 1.5 years between 1985, 1st of August, and January 1987. Gauge that, look at it, etc. How did I relate? How did I performance, etc. Whom did I lead? Whom didn't I lead? Because even when you get people from, people, your clients coming in and working happy, and you do a job and you get results, there must be a sizable amount of leadership. We have not been in these places or in big office because nobody gave us an opportunity. You cannot hang us for that. Look at my personality, if you are able to. I don't know, that will be difficult for you as a commissioner. My personality, where have I been? Go to my village if you can at Chuka. Look at what I do. Do I own a cow or two, and how do I feed them, etc. Leadership is not an issue of office. And if that is not answering enough, learning does not take centuries. It is just a question of if we landed into that office today, would be able to sit there. Two, you are working with a team. I must not be ICT. I must not be HR. But we have people there who are HR. If I find them inadequate, I'll be able to bring expertise. So you, a leader, just sits there and implements a policy and shows the way. I went to the KIA for a course a long time ago in my TSC days, and we were taught about the difference between a leader and a manager. This is the difference. A leader thinks, states, and leaves. A manager is left by to implement. So if you have the idea, the implementation is not an issue for the leader. You have the idea and you say it. What you do as Chief Justice would not outrightly abandon management. You'd have to combine the two and be on the lookout. But we are saying that you cannot do everything. I am not a teacher, but all the schools around here would get taught if I was in charge of them, because I would get teachers and good teachers to do that. So you incorporate and you apply whatever resources, human resources you have to be able to get what you want. You lead.
Now,
and others follow.
My Lord, now you said, again I'm picking this from what you said.
Please.
I only have 3 more questions. That after you came back from the political seat that you attempted to get, you started legal practice, which lasted for 11 months. I'm just quoting you verbatim.
Please.
11 months, and then you decided to go back to employment at a Teacher Service Commission.
Yes.
Now, I'm just trying to understand what made the law firm not last beyond 11 months. Nothing wrong with that, but I just want my understanding so that I can see how to place you in terms of...
answer. I left the Sharia house to go for NISI. NISI was disastrous. I realized that I did not have any future. I was not a politician. I would not cope with it. So I came back to Nairobi to pursue my career, my profession. In the absence of anything else, I opened an office. I have always known that I am not a practitioner. Legal practice, private legal practice, hands off. That is not my line. There are so many other things I can do in law, with law, but not a successful legal practice. I'm not your personality. I am myself. I have my limitations. I have my gifts. Private legal practice is not one of them. That is why you realize that after my horrid departure from the TSC, I go to Ongata Rongai and sit there and start a practice as a pioneer counsel in that place. 3 years down the line, 2 years down the line, I began teaching. Because for me, teaching is more of myself than a legal practice. In fact, if I had continued, I would have abandoned the legal practice altogether, because that is not myself. That is not my gift. Those are not the areas where I score, and go to precisely where I score. 2, all this time I had realized that I am a public servant. That is why I sit here today. That is who I am, and that is the best. If you wanted to get the best results in me, public service.
But you see, again, now my worry is that we could give you now the position of Chief Justice, and you are unable to, being a judge is one thing, but being a Chief Justice with all these many responsibilities is a different thing altogether. It's a different ballgame. So, again, I would be worried that perhaps, you may not be able to manage that position. I keep reminding you that for us, whoever we appoint, we must be able to look in the eye in a Kenyan and say, this is why, So wouldn't that be one of the reasons probably that could create some doubts in our mind that perhaps we could give you that 11 months later you're not able to manage? And that time, and you see the removal process is a different thing altogether.
No. I don't see it that way. One, I don't see the link between, a Chief Justice and a private legal practice. Good, you relate with the practitioners out there, but you're not practicing yourself. You know how it is done. The only dilemma is that you cannot do it on your own. It is not your line. You may not be interested. You may not even know. You cannot be hung for that. This is a public office, Chief Justice of the Republic of Kenya, which, any able leader would be able to do, particularly if you are fast, like I am. You'll be able to sit there and get everything connected. You have everybody that you require. And if you don't have, you could always bring them in so that you use them to get what you want. You are the leader. Legal practice, private legal practice, and this office, this grandiose office of Chief Justice of the Republic of Kenya, to me, not.
Second last question.
Please do.
Now, you see, if you become the Chief Justice, you'll be also the chair of this commission, JSC.
Yes.
You would actually come here and now be a primus inter pares. You'll be the first among equals. Now, I'm just wondering again, because managing us, you can say we are all from different. We are representing different constituencies, but you have to put us together, and we are one cohesive commission, chairing us, and all that. And of course, it's not an easy task. Eh?
It will never be easy.
Now, tell me, what is it that you think you have that, gives you that ability? Because you see, this commission, of course, it has immense responsibilities vis-a-vis the institution of the judiciary. Because again, I'm looking at your CV, I'm looking at what you've done, and I'm still not seeing what is it that can be able to put you in that primary position of being able to make the commission function in a way that it's able to undertake its duties. And as you answer in that, this is the same commission, without getting into many details, you've already had so many issues with it, which you are aware of, and then that are still outstanding. So I'm still wondering, how would that work? Because see, again, you can see this, the Court of Appeal is talking about tidiness, even as you are making decisions, as you are making certain considerations. I'm just wondering how tidy would that be? That our chair now, will the chair come and start dealing with his issues first with us in the commission, or shall we get down with the business of making sure the commission is able to deliver on its obligations both to the judiciary and the Republic of Kenya?
The issue of ability is not an issue whatsoever. The Judicial Service Commission has its obligations, which are dictated by law and practice. Who is in charge or not in charge would not make a difference. In this sense, if we are committed to what we must do to fulfill our mandate as the Judicial Service Commission of the Republic of Kenya, and our roles are explicit, what it would require is that we move on to create work plans for implementation and acquisition of the end result. I would lead in that. But I would believe that I'm leading 11 others who are committed, as knowledgeable, who have the goodwill. So that where I sleep, you raise me up. Where you sleep, I raise you up. So it is not this work. If the entirety of the Judicial Service Commission that we have today left, in a week we would have another Judicial Service Commission, and there would be continuity. The issue is not, where you have been. The issue is, are you able? I believe I am very, very able. I have a proven record. Go to Chuka, you look around, you see what I have done. Even, my coffee shop, I will tell you, this person is able. etc. I have answered. How satisfactory the answer is?
So my last question, my lord.
Sorry, if you allow me, good Commissioner, there is the second limb of the question, my issues with the Commission. Will you allow me to answer that?
Yes, go ahead.
Go ahead. Thank you. My issues with the Commission are not personal. My issues with the Commission are as such issues with the Commission. The Commission would have the ability to deal with all those issues independently and freely, even if I was a chair. I'll just get out. That is what we do in the church or in any other meeting. If you are conflicted, or it is a matter which conflicts you, you take off, and the others make a decision. Good enough, yes. 9 complaints. I do not generate complaints. Complaints are managed by the Commission, and we shall not take that away from them. So even as a Chief Justice, as late as the other day, we knew and we had, it was public knowledge that the Chief Justice had complaints which the JSC would even ask him to answer for consideration. None of us is immune, and I thank God because Kenyans are at liberty to raise these issues, and we shall not take that right away, because that is what our independence is all about. We are accountable to them. They can raise 1,000 issues against me. I'll answer. If I fall, I'm indicted, good enough. I pay the price. So my issues do not have nothing to do with
I'm all right with that, my lord. My final question.
Please do.
You see, the hard reality, regardless of what we may think, whoever is the Chief Justice must be somebody who must attract the respect of the peers, and of course, even as they enter and they take that position, Kenyans can say yes. The person must come up with that. It must be somebody who people can say yes. That's a person who is befitting of the office. I'm not saying you don't, but Do you think you have that? That's all. That's my last question.
Thank you, and thank you again. We are looking for, yes, it has been said very loudly, and I know that, and I'm not cheating myself. I can mark myself 90%. Kenyans have loudly said that is a man, the man of the moment, in the airways. I'm not talking about communication Commission of Kenya. No, I'm not talking about radio. I'm not talking about TV. But if you feel the air around Kenya today, it is very clear. We have. I said that this is a man. Did you see the 2 reviews I had on the newspapers? The one on the Standard immediately after Easter, and the one on Sunday last. That is what I presume is the voice of Kenya.
Okay, thank you very much, my lord. I wish you well.
Thank you, and welcome.
Thank you very much, Your Honor. I will now request the Commissioner AG to ask you questions.
Thank you, Honorable Chair. My Lord, Justice Marete, I would not wish to belabor you with too many questions, because many of which I would have asked have already been put to you and you've answered them. But just to follow up on what Honorable Commissioner Macharia has just been discussing. You seek this office against a backdrop of 35 odd years of experience. And you have attempted to persuade us that you are indeed the man for the moment. And you have sought to demonstrate that you would be able to learn and learn very quickly. And you said, my Lord, that you would engage the public as well as the judiciary staff, make them happy, motivate them, etc. Would you be pleased to tell us, Your Lordship, which existing organs within the judiciary currently which you would engage to enable you learn quickly and to achieve the mandate of the office? There are various organs existing within the judiciary as we sit here. Which are they, and how would you engage them?
One, we have offices and officers. The office of CRJ is very instrumental in the running of this institution. She's the CEO of the institution.
That's one.
The office of the very able Deputy Chief Justice. She's been in that position for long enough to be able to even be Chief Justice herself. It will require a hand-by-hand contact. For a year, for a month, 2, 3, 6, 1 year, etc. That collegiality and the cordiality between those 3 offices is like the issue is resolved. Because through the Honorable the CRJ of the Republic of the Judiciary of the Republic of Kenya, I'll be able to access all the other human resource which is available through reports, through any other means. The CRJ, the time she has been there, knows the judiciary and its operations throughout, inside out. And being here and available and knowing her personality so well should be a vital asset in helping us walk through this journey. The Deputy Chief Justice is here. The Commission is here in entirety, a big force, Judicial Service Commission. You didn't go to the other associations, independent associations for like the KMJA, the Kenya Women Judges Association. These are institutions and organs which would be able to tell you and give you what you may require in terms of learning, and be able to support you as and when you need it. They are your colleagues. You are not their senior. I would be able to work within a class 2 kid today and transact business. Why wouldn't I be able to work with everybody? Inequality, that is my terms of trade. Everybody who deals with me we deal at the same level, at parity. So all this crowd here of senior officers, the JESC, KMJA, the association representing judiciary staff, all those organs, if I wanted to borrow from them, it would be instant. And I believe they would be willing to lend a hand. And there we are. The judiciary, this is not personal. The Chief Justice is just there as a figurehead. The OC belongs to all of us in equal shares. And Kenya, equally.
What about in relation to the courts, my lord?
The courts and the administration, we have heads. The president of the the Court of Appeal. We have the various, principal judges, the principal judge of the High Court, the principal judge of the Employment and the Labor Relations Court, the presiding judge, or in quotes, the principal judge of the ELC, big consults. Beyond that, you can even go to the individual judges. I'm accessible to virtually, as Chief Justice, virtually everybody. And this place is rich. Do I repeat that? Look at who is sitting besides you. A giant, insofar as performance is concerned. An intellectual par excellence. And here we are. There's nothing we lack whatsoever.
Thank you very much, my lord. Now, you discussed the jurisdiction of the Supreme Court in relation to election petitions. Would you be pleased to tell us, my lord, whether you consider that jurisdiction should be expanded or restricted generally in the Supreme Court, but not in relation to election petitions?
The Supreme Court should be very, very guided and very guided in the way is the jurisprudence in the way the jurisprudence on election petitions, and generally every other matter is concerned. We read from Kenyans or even other scholars outside this country that as at the time of the elections in 2013,
my lord, please, you explained the aspect in relation to election petitions. I should ask you now to deal with the jurisdiction of that court outside the framework of election petitions. Should the jurisdiction of the court be expanded or restricted, and if so, why?
I would not think that it should be expanded, because one, let's look at this at the basics of your question. The Supreme Court has expressed itself on that, and the ratio decided is to the extent that in all these other courts, the High Court, the Court of Appeal, etc., we have competencies which will be able to deal with any matters constitutional. I should even deal with that down to the magistrates' courts. These are professionals who have the capacity and the competency to deal with matters constitutional. That being the case, and looking at the circumstances and the basis of the Supreme Court, I would think the safest thing would be to narrow it, not to expand it, even in these other matters, so that you are restrictive and you are able to guard what you take in and do it very, very well, so that you become a guide, one, you become an authority in the region, and you are able to meet the expectations of those who created the Supreme Court. Because the Supreme Court has got its own historicis, and there was that which it was intended to cover. I would implore a very, very conservative and restrictive approach to jurisdiction in the Supreme Court, so that we are able to, one, cope, two, allow everybody else down there, the Court of Appeal. We are talking about rival jurisdiction as we speak now in the out there. I mean, we are talking about a rival jurisdiction, things which are extremely dangerous. Let's allow everybody to do their bit. Let the Supreme Court do what it was intended to do by the drafters of the Constitution through, the people of Kenya.
What was it intended to do, my lord?
Primarily, the Supreme Court was intended to deal with the issue of a presidential election. In fact, if you are lay and you heard of the Supreme Court in 2011, 2010, etc., post-Constitution, what everybody told us was that that was the most critical matter. But you know that cannot be done forever. The Supreme Court becomes a lead court, and it was intended to be that, lead in terms of jurisprudence, so that you are not doing 1,000 matters. Do 5, 10, 100, and do them so well that anybody looking at them will be saying, I was guided on A, B, C, D. The thinking is brilliant. These people had their time in so doing. They were not rushed like we are rushed by backlog, so that you are able to come out clean and guide Kenya on its governance patterns. The framers of the Constitution put it right. Issues of constitutional interpretation, issues of constitutional interpretation and interaction, good enough. But now, when the Supreme Court itself now sits, what does it interpret this to be? And when it does that now conform with the expectations of the drafters of the people of Kenya?
And my lord, how would you then, if that is your belief, what leadership would you offer in that jurisprudential development?
One, the issues which are in contention, the issues which have been raised by the Kenyan public and any other interested party, international, scholars and academia, etc., I would subject that to a public debate. They would be thrashed out, and they would have a policy which is not guiding on the decisions of the Supreme Court. We cannot tie the Supreme Court. As we do it at a public level, the Supreme Court would also be sitting to think. We would create a situation of reflection, a situation of introspection, a situation of consultation and rethinking, so that if we are convinced that there is a problem, we are stifling the other courts, we would deal with that freely and openly. But it would require the Supreme Court on its own to sit and reflect, introspect, and generally see what is available and what is offerable insofar as what we have today is concerned. Very convincing, very able, and a very good jurisdiction, if you ask me. But issues have arisen. If you read any of those matters and opinions and decisions, they are fantastic. They sound good and etc. 100%. But now when you come to the ground, other intellectuals are raising issues, and we cannot ignore them. They are part of our stakeholders. They are Kenyans. Quietly, we have issues even which are internal. I mean, like the critique on my decision, the Court of Appeal judgment made very firm interventions on my judgment. This may not be that formal, but we have other areas which may be feeling uncomfortable with what the Supreme Court is dealing with and the extent it is. So we bring everybody on board, we thrash out the issues, we make recommendations and solutions, we hand it over to the Chief Justice, not as a direction. The Chief Justice would take it up and deal with it is a style with his judges at the Court of Appeal. Because the Court of Appeal can only recreate itself. We cannot go there and hammer them into recreation.
Thank you very much, my lord. Let's move on. Just a couple of more questions. You've heard this phrase, why hire a lawyer when you can buy a judge? You familiar with that?
Very familiar.
If you do become Chief Justice, what would you do differently to deal with corruption in the judiciary?
One, surveillance. It is one thing to say that you're dealing with corruption, and this is a very thorny issue and a very, sensitive issue, because whoever would listen to me answer this would pick quarrels with me if they were in that side. Thank God I don't belong there. So, put effective surveillance mechanisms so that we are able to detect these cases. You know, corruption is a very personalized affair. It's not an affair which, is public or publicized. It's like any other very personal, areas of our lives. I don't want to mention them here. So that this two-way matter, unless the Chief Justice and his officers do very strict surveillance on this, and also deal with it very firmly, because we cannot sit here and pretend that we are serving justice when we are doing things under the table. If you are not writing a genuine judgment, then you have no business writing any. You should walk home. So that when these things are influenced by not even corruption, call it bribery, is that cheap? By bribery, you are telling us that we are not in serious business. So the Chief Justice should put his foot forward, should do surveillance and employ any other methodology, including the EACC or any other mechanisms to arrest corruption. The Kenyan public would never be happy like I would offer them if they were still being asked to pay 20, 30, 40 shillings, 1,000, 2 or 5. And it's so unfair, so immoral that I will not kick anybody, but I will not be amused. I'll do everything possible within my means to eradicate this entirely.
My lord, what mechanisms would you employ to ensure that corruption cases are heard and determined expeditiously, which is not currently the case?
Did we agree that, or did I submit that I would, in the next 3 years, I'd want all my matters determined in 360, or if you want to increase that, 365 and a quarter days, so that in every 12 months, a matter which has been raised with us is determined. We have an issue with the criminal justice because it is a broad spectrum. We have an issue with corruption cases. Corruption cases and what is happening in the Supreme Court, elections, is a class affair. It's very rare that you find people who are involved in corruption being my brother who does his beans and bananas at home. Not him. It's somebody like me, you, and everybody else. And do we call it class? People who are up there, the elite of this society. That is why it becomes very, very difficult to deal with this. But do we have judges in that court? Do we have adequate staff? That is the first question. Are they happy? Have they raised issues why they are not able to deal with these matters? You'd have to get the background material if you've not been there. When you get that, you fix it and insist that these matters are done on time. In fact, on time. And in the first instance, you should not have any matter which takes more than 2 years. The second instance, you are getting to 18 months. The third instance is 12 months, and it is doable. If the prosecutor does not want to do their matter, they can as well keep them or prosecute on their own. The Chief Justice Emeritus, my good senior, David Maraga, always told everybody, bring your evidence, we shall deal with it. If you don't bring your evidence, don't we have mechanisms for dealing with the matters? Because backlog, people bring their matters here and they go to sleep. You bring a corruption case or any other matter which is a criminal, etc., and you go to sleep. Litigation is a business. They are professional litigators. What they litigate, we do not know. I've learned that from those who are in the judiciary earlier than myself. Those who have worked in the judiciary have that advantage. My spouse was here for 38 years. She retired the other day as a junior officer. Don't get worried. The Honorable Attorney General. And we know that there is business in litigation. There is business in delaying litigation, etc., etc., etc. If we sit as a combined force of the judiciary, we'll be able to eradicate this, to stumble that.
My Lord, forgive me for interrupting you, but you've been a judge for 8 years. And even if you haven't worked in the corruption court, I assume that you have some knowledge of the workings and the impediments that face the judiciary. You are now Chief Justice. What steps, what practical steps would you take to eradicate some of these problems that you're alluding to?
One, identify the issues, the problems.
The problem is delay in determining cases that touch on corruption.
Get to the court and address the officers who work in that, the judicial officers who work in that court. Get to the court and address the administrators of that court. Get to the court and get their experiences. Why are we not able to deliver? Why do we keep a matter here for 3 years, 5 years, etc., etc.? When you have that, get to set targets, clear targets, which are permissible, acceptable, or doable. You will be able to know from the experience, they'll be able to give you data on what is doable and what is not doable, and why it is not doable. When you have all that knowledge within yourself, you devise strategies which make it work. I know it can work. I know it has improved. I don't want to mention names. I know it has improved, and it is coming out well. It can be done.
Thank you very much.
Honorable the Attorney General.
Last but one question, my lord.
Please do.
Is the judiciary independent?
The judiciary is independent. I'm very, very happy about that. I've been here for in July to be 9 years. Nobody whatsoever has wanted to interfere with the matter I was doing. We can feign a lack of judicial independence, or we can be participants in that non-independence. When you create situations which mar or stifle or stumble your independence, like corruption, you are not telling me that you are involved in corruption and then you are also doing an independent, you are independent as a judicial officer. Zero. That is not the reality. The judiciary is important. I am a living independent. I am a living example. Nobody in 10 to 9 years has interfered with my decision making. Look at it all over. Who has come here to hammer anything on the judiciary? What haven't we done? Presidential elections? And they walked free? Very sensitive matters and walked free? Let us not point at anybody. We are independent. If there is an issue of lack of independence, then we shall say that we are our own worst enemies. We collude to create non-independence. So far as I'm concerned, we approve 1000%.
What role do you think the other two arms of government should play in protecting the independence of the judiciary, and how would you as Chief Justice encourage that?
One, the issue of a constitutional government, starting from the judiciary, going to the executive and the legislature. And a constitutional government which also appreciates constitutionalism. We have had some very good writing by my good friend, the late Professor H.W. Okosogendo, Constitutions Without Constitutionalism. That is where we start and end. Because you are singing this, you are doing this. You preach this and take the other. If the other arms of government took constitutionalism seriously, this country would cure within a week. If we all took it upon ourselves to practice what is right, to eradicate impunity, we will not require a week. Do you remember the NAC revolution in 2002, which lasted only 11 days? We were there. We had it. We can have it. With the participation of all the stakeholders, the executive, the legislature, and ourselves. Combine and liberate Kenya. That is what we are called upon. That is why we are paid so heftily by the Kenyan taxpayer. Did I answer?
I'm much obliged, my lord, and that will be all from myself. Thank you very much, Honorable Chair.
Thank you so much. It's been a big pleasure, and always welcome, my senior.
Thank you very much, Your Honor. I would like to ask Commissioner Gishohi to continue the questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Yes, I'll be very brief because most of the questions have been alluded to, but do allow me, if you don't mind, Honorable Judge, just to focus more on the Commission. And I want us to remain with the Commission as much as possible. You have reflected on this period, 2011 to 2016, the foundation, 2016, 2020, 21, sustaining. I want to be very clear. If you get this position as the chairperson of the Commission, just one thing that you'll be able to do or to initiate to deepen, broaden what you are, what the Honorable Chief Justice previously, those two periods, have actually put in place, as far as the Commission is concerned?
Insofar as the Commission is concerned, on transformation, I would bring up the Commission to appreciate its position vis-a-vis the judiciary. One of the biggest issues we have today, and it was mentioned on Monday by my good friend Justice Chitembwe, is the issue of management of complaints. That is the elephant in the room. If you ask me, I'll write 1,000 pages or tell you a story for 10 weeks on what it costs, the opportunity cost of answering a complaint.
Complaint?
So what we are saying is let the JSC take a decisive role in dealing with complaints. I don't know whether Commissioner Gishoi, not Gishoi, but the representative for Advocate Macharia is here, and I want to use my example. You want to please allow me that.
Without going into the details about it.
Yes, in 2013, I get a complaint. In 2015, we deal with it, and I am successful. In 2019, the same complainant brings a complaint against 6 of us, 5 in the Employment and Labor Relations Court, 1 in the High Court. And the JSC forwards it to me for answer. That is the issue. What is the capacity of managing these complaints?
Very good, Judge. That's a good complaint. I want you to look at the issues, and it was raised earlier on, that you are the chairperson of the Commission, you're the Chief Justice. And I want us to focus on the organs of the Commission. Organs, not individual offices, organs that you can utilize, that you can be able to touch, that can you be able to make those changes. As chairperson of the Commission, as Chief Justice, could you share with us those organs within the Commission that you can either strengthen or establish or abolish? I am not versed with the workings of the Judicial Service Commission. I will not score 40% on that one. But I can mention the areas which I would touch, and then maybe it can be linked to the organs, so that when like the issue of complaints, the body behind that one would have to be streamlined. The issue on the growing of development would have to be touched on, because this is where our infrastructure is infrastructure and the other materials that we utilize, like the ICT is anchored. We would have to touch that. The issue of human resource is very, very critical, because without human resource, we are as good as dead. We are not in business. We can have all the courthouses, all the buildings, all the it will not be any business. So those critically are the 3 areas that I would like to touch. Start with. Let's take human resource, because that's very critical. And you talked about making the staff happy, not to fool around, and you talked about a result-oriented approach. I want us to focus on customer-oriented approach. You have been saying about being happy and the rest. We are used to have the customer-oriented approach to make sure the staff are able to produce in terms of productivity. What will be your targets? What did you do to make sure that you have a very clear strategy on how you are going to motivate your staff?
One, let us agree that staff will require facilities to motivate. Staff will require education, training, because I could as well give you an elephant, but you do not appreciate the value of an elephant, so it is not a serious business. Education and training to be able to understand where we are, what we are doing for them. I will allow staff to have their liberty. In fact, if I became Chief Justice, like I suggested 3 years ago in a colloquium, I would allow every officer of the judiciary in their respective capacities to, if they choose, form trade unions. Why? Because it is easier to deal with something which is organized than to deal with a hazard and amorphous things. Groups. We have quite a number of suits on salaries. We have issues of confrontations between the JESC and the staff, etc. This can only be achieved if we have a structured system for those staff members to deal with us. It would even be time years and a better way of dealing with it, because we don't have everybody working individually to deal with their matter.
Very good.
Please.
Talking about training and developing the staff, I want you to focus on the role of GTI. And as chairperson of the commission, where would you place GTI? What kind of facilities would you give that institute to make sure that it is able to give the service to the staff and to judicial officers also? GTI.
The JTI, you know, today is not the JTI we had 8 years ago. JTI was big, it was brilliant, and it was very, very good. You'd go there and meet on international, conferences. The JTI, I anticipated even from then, was a JTI which was a complex. I'm not quoting or copying anybody. This is my experience the first time I landed at the JTI. A complex. We do an institution which is self-contained, which is good, which is a good to go.
So what has gone wrong?
I would not know. Earlier I said that I'm not an insider, and it was not...
But Judge, you've been here for 9 years.
Is that insider?
Yes, 9 years, long enough. 10 years, kid is going to primary school.
I think we may have to revise our English.
Okay.
Insider means somebody who is actively involved in the administration of the judiciary.
Okay.
I am a judicial officer. I'm inside, yes, but at the periphery. Those areas are not mine. Okay. But on the JTI, that one, without even from where I am, because it's an institution I love so much. It's a place I value so highly. Firstly, give it the requisite personnel. Okay. We had a very good JTI in the reign of the Honorable the Attorney General. We had a very good JTI in the reign of Justice Professor Ngugi. Okay. Excellent. It went diddling, I believe, because of finances and maybe administrative issues. Okay, I do not know. But what I will do is firstly facilitate competent personnel to deal with the institution. Secondly, deal with it, have international linkages. The personnel who go there must link it to the other international similar institutions, or even greater institutions, so that it becomes a benchmark. We can benchmark with them. Infrastructure.
Okay.
We would have to do it well, so that you have been to the KIA. It has changed names. I can't remember the infrastructure. The KIA. Which is, I've been there twice, thrice, I can't remember, but it's an excellent facility for mobility in government. Government doing its own affairs.
Okay.
JTI should go that direction and even improve on that. Somebody suggested in the interviews that we should own it. There has been a resistance. by the owners. That one I know. I'm a friend of the good Professor Ngugi. So when that kind of issue arises, we should not stick there and moan that they are resisting. Look for land and start afresh.
Okay, Judge. Let's move on to something else now.
Please.
You're talking about financial independence of judiciary.
Yes.
Lack of funds.
Yes.
You need the funds. The Kenyans pay money, taxes to fund the judiciary. If you get the position as a chairperson of the commission, and you need the funds from government, from the exchequer, would you share with us, as the chairperson of the commission, as the head of the other arm of government, what strategies would you put in place to ensure that we get adequate funds? 3 strategies, please. 3.
1, take care of whatever we have from the government of the Republic of Kenya, the Judiciary Fund, establish it, take our share and claim for more if it is possible. When we have that, we are well anchored. If that and it is not going to be enough, then we do fundraising. Fundraising is a contact with our friends and other stakeholders so that they assist us in raising funds to do a magnificent JTI, buy some 20 acres of land and get money to do it and raise it in the next 3-4 years.
Those are
doable. Fundraising and donor.
Donor fundraising.
What we have not looked at is, being conservative in a way, prudent and a conservative user of what we have. Government is known for buying this pen for 500 shillings. I started using this pen in my TSC days. I don't remember what it was that, but I know this pen costs 230 shillings. At most 240. If I move to the Prestige up here, I'll get it with my 230 and 40. So prudent utilization of what we have.
Okay.
We complain over nothing. We just abuse resources.
Honorable Judge,
please.
You are the chairperson of the commission. You are the head of this arm of government. You are talking about the total budget of judiciary. Yes? And I want to hear from you as a chairperson of the commission. And you know the government cycle. I've seen from you for a lot of years. You have 17 years in the AG's office, 5 years in the TSC as a public officer. I mean, how do we fund other organs of government? What is the system? What do we use? Apart from fundraising. You fundraise for judiciary. The following day somebody comes for dispute in your court. So I want to focus on that law the Kenyans are responsible for funding national institutions. And you are the head of judiciary. You are the chairperson of the commission. How would you, the strategy that you make sure that you get enough funds?
You have to put in a hard bargain.
Hard bargain.
Our issue is history. From 1963 to date, how has the judiciary been treated in our national politics? What position have we taken? Below, even prior to 1963, how was it taken? Because we have had a judiciary here for the last 140 years. This is what we must dismantle. We must put out our foot forward and acquire our position. When you acquire our position, we must be able to say it very, very succinctly that you are not doing us a favor. Treasury, you are not doing us a favor. Of course, politely.
Okay.
Otherwise, you will not get anything. But before you even get to treasury, we have the three organs of government: the legislature, the executive, and they are headed by the CEOs. We have two speakers of the National Assembly. You will find it interesting to sit as government in totality. And when you sit with the government in totality, you don't even nothing is not an issue of power, it's not an issue of possessions, it's not an issue personal.
Okay.
Let us do Kenya proud. And in that way, you'll be able to say, this is this, this is this. The biggest issue with Kenya is that we go very personal, not in government, everywhere. I don't know whether it's a human issue, humanity issue, or is a Kenyan issue. But we go very personal over very small things.
Okay.
And there we are. But you can get out of this.
So
you can teach everybody out of this.
Okay.
You can have organized and constructive discussion with the other heads of the other government
So
institutions.
if you're talking to the National Treasury as the chairperson of the commission, where are you walking to in the National Treasury as the chairperson of the commission?
As the chairperson of the commission, I would walk straight to the cabinet secretary.
To the registration? The registration, to what office are you will be walking to? In the
That is
registration?
executive. That is
The treasurer is okay. The CS. I'm now on the registration.
You go directly to the speaker, to the chief executive of the legislature.
To the speaker.
Justin Muturi and the other gentleman. Now that I'm under pressure, I may not remember his name.
Okay. So
You
there-
go to them and you chat it out. You thrash
Okay.
out issues for Kenya.
That's fine. To the executive?
His Excellency, the President of the Republic of Kenya.
Oh, very good. Finally, the judiciary, I'm sure this one you will have an idea, the Judiciary Leadership and Advisory Council. I presume that is more or less the cabinet of judiciary in terms of the internal organization.
The Judiciary?
Leadership and Advisory Council.
Yes.
Are you aware about it?
JLAC. I am.
Yes. If you have to get there as a chairperson of that council,
Yes.
the first meeting or the first two meetings, what will be your agenda?
My agenda would be a review. Firstly, a review or an assessment of how far we have gone insofar as judiciary administration is concerned. And having achieved that, I would, in the next meeting, I would get to foment the way forward. I mean, where have we failed? What is our success? Do we have any balances? And if we have balances, how do we move? What is our way forward?
Okay. My final question, Madam Chair, Honorable Judge, you talked very passionately about staff and making staff happy. But you also need the staff to produce, to be productive, to be efficient. In the event that staff are not that productive or efficient, someone is behind the targets. As a chairperson of this commission, and those issues come to the commission from the Human Resource Committee, what kind of punitive or kind of collective measures or framework would you have, would you recommend?
With staff, these are human beings, these are persons.
Yes.
You would have to be very kamhadi, very cordial, etc. So that you get to win them. I talked about winning them or buying them.
Yes.
When they are with you, they'll be able to get back to Kenya and make Kenya happy. When an eventuality like yours comes, and they must be there because we are diversified, we are human beings. Our capacities, work is a gift. You're gifted to work ABC. They are the so-called lazy persons. That is the word we use. They cannot do as much. They are those who cannot do anything.
Carrot and stick. Carrot and stick.
By whatever name called. Thank you.
Yes.
And you have to be able to know how to manage that. And human resource has got its own programs for dealing with that. We are not saying that we just want to make friends. No. We are making friends with a view to attaining something for this country. We want to transform the entirety of the country, not necessarily the judiciary. That is why our people must work and live, free Kenya.
That's enough for me, Judge. I didn't want to pursue it further, but finally,
Please.
You are in the TSC.
Yes.
And the TSC came to a point where you had to disengage.
Yes.
Without going to the merits of the matter.
Yes.
There was retirement in public interest.
Yes.
The public interest.
Yes.
Just very briefly, what was it about?
I have made mitigating circumstances. I have that here.
No, you don't have to refer. Just
one. I was given a letter headed retirement on public interest. The first notice was thanking me. The second issue was wishing me well, and it had ended there. In law, or even in practice, or in sense, when it is such a grave matter, which you must learn to live with, please explain and say, on this ground, etc., we retire you, and on public interest. Okay. Nothing. I'm still blind.
Okay.
I would have to walk to the TSC to know why I was retired on public interest.
Thank you, Chair. Thank you, Judge. Wish you well.
Thank you, and thank you again.
Thank you very much, Your Honor. Your Honor, would you want to take a short break?
I am okay, but I'm not speaking for anybody else. I am okay. Thank you.
Okay, if you're okay, then you're okay as commissioners.
Please.
So I'd like now to call upon Commissioner Koskei to ask questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Mine will be very short. My first question is, if you are a CJ tomorrow, what are the first three things that you will check when you wake up in the morning?
The first one, and which will not take me an hour, is the issue of the 41 judges. Earlier on I said that I would get the Deputy Chief Justice, the Acting Chief Justice, as we speak, the CRJ for a meeting in the next 1 hour. The next matter I would deal with is the issue of ascertaining our financial position, and the CRJ is here, so that is in our fingertips. And on that also, I would wish to understand from herself her operations. What is due? What is not due? How is it done? I do not know how it is done. She would have to teach me instantly.
Judge, I mean, I really want to know. You see, when I'm asking you three important things that you perhaps will be, checking almost every day when you wake up. Not as you are entering then you are entering judicial. No, three things. The first three things that when you wake up like this, you have to check as a Chief Justice.
One, I would have to compare notes with the Chief Justice to check on the issue of finances. That one is very critical because it can cripple us. In fact, the publicity itself is bad enough. We need not have stolen. When we have a story going around that this and that has happened to our finances, it becomes a crisis. We get ungovernable.
Number two.
The second one is checking on the morale of our staff. What is happening in Nairobi? What is happening in Mombasa? Every other day you must ascertain that all is well. And if it is not well, you address that. The third one would be, that one would be on performance. The Directorate on Performance Management, the CRJ and the HR, our heads of stations would have to constantly on a daily basis, maybe daily or 2-day basis, give us a brief on how we are progressing insofar as our service areas are concerned. So
thank you very much. I think you've answered.
Please.
My second question is on customer service. you are an insider, though you are denying that you are not an insider. 9 years in a particular institution will make you an insider in all the description and definitions in English. So, in judiciary, there is a problem when it comes to customer service, and the public are always concerned, especially a very long turnaround, time on payment of funds or fines, the funds of bails, and even the reception. If you go to courts, people get confused. They don't even know, they have no direction. People get lost. They are in corridors. Even some innocent people have been even jailed, as you almost jailed your staff. What strategies or reforms will you introduce to provide high quality and perhaps effective and efficient customer service in the entire judiciary?
One, I am not sure whether we have a policy on a customer care or service. If there is none, we would have to do one in so little time. Where so little time means 90 days. When that is hard, the next issue is commitment to duty, morale in doing that work. I know 2 offices in the judiciary which are par excellence and which score a lot. I don't know whether they have the permission to they do an excellent job. One is strictly customer care, the bench liaison at room 440 up there, the registrar of the High Court, excellent. The transport division is excellent. Why have they been able to achieve that? Because of their morale, their commitment to duty. So you inculcate commitment. I need to be firm on this one, because how do you achieve satisfaction by the Kenyan public without good custom service? It will not be available. So you train, you cajole, you enforce and achieve. And those are things, if we have a policy, even without a policy, those are not the things you require 2 weeks to achieve. The CRJ is here, everybody is on the ground, there's nothing lacking. So it's just a question of a change of attitude. And that one you can get. If you have people who do not want to do that, you have your choices. You are an administrator.
Thank
and
you.
The rules of the game are known.
Thank you. You have answered, Judge. You have answered. My third question is on statutes that are always used to run the management of public institutions. And you know, there are 5 main ones. One is Public Audits Act 2015, Public Procurement Disposal Act 2015, Employment Act, PFM Act, and the judiciary also there is Unclaimed Financial Assets Act. I've seen that you are in TSC, which is a public institution.
Yes.
And you are in charge of the legal desk.
Yes.
Which means that you are a member of the tender committee, obviously.
Yes, I was a member of the tender committee very briefly.
Now, and you must have interacted with the law, procurement law. I wanted to get your thoughts. You know, Procurement and Disposal Act from Exchequer and Auditor Act of 2001, and we came to 2005, the one that now you interacted with for almost 4 or 5 years. They had very clear objectives: transparency, accountability, value for money, etc., etc. I want to know, has this law, or to what extent has it, achieved its objectives, and what are the limitations of this law? Because you are coming in as a CJ, and every other time you're interacting with this CRJ on issues of management, issues of governance. I really wanted to understand, because this is one statute that it will be on your desk every day. Judge?
I'll attempt to answer your question, but not based on my exposure at the Teacher Service Commission or anywhere else. I am not exposed on this whatsoever. I lasted very, very little time in the Committee on Procurement in the Teacher Service Commission. Not 3 months out of my 5 years. I think there was a coup d'etat and I was removed and concentrated on what I was supposed to do there. So on that, there's an issue of what we have as the law and what we have as the reality. It is one thing to have the law, it is the other thing to have it practiced. That is a big issue we are having with the Constitution of Kenya 2010, and that is why there is a lot of hullabaloo in this country. The same, going back to where you are starting, this is a procurement law. We say one thing, we do the other. That is where we are. So how would we be able to deal with that one? Monitoring, enforcement, and strict enforcement. We'd also be able to law as sanctions, deal with cases of defiance, deal with cases of infringement of what you are supposed to do. Lack of due diligence, it requires monitoring. This is an area where we require a lot of monitoring, because as we speak, procurement in this country virtually everywhere is an ISO. In fact, I'm very, very happy that to us in the judiciary, we've not had that kind of mammoth issues. Thank you so much, those who are involved in that. But we know what procurement is. We know the law is available, etc., etc. Why don't we choose to do the job? And because we know who we are working with, why don't we choose to deal with them so that they are able to produce? Why don't we choose to even retest our integrity so that we are able to do good work? Buy this pen at 250. I mean, I would not mind. We are not going, I mean, procurement laws are not going to allow us to walk to the bookshop out there and buy, I mean, formal stock. Personal, yes. But when we do that, let us do it without abundance.
Thank you.
That is the work of the CEO.
Thank you, Judge. Thank you, you have answered. My other question, which is my second last, is that currently there is a perception out there, especially from employers, that your court, that is Employment and Labor Relations Court, has been captured, that it is a court for a labor movement that gives direction, even to when the current constitutional amendment that is going on now. One of the most senior labor movement leaders said, you can change anything, but don't touch my court. And they refer to a court. What do you have to say about that?
We shall entitle every Kenyan to what they want to say, as long as it does not offend the law. It is their constitutional right. It is their basic human right. We entitle them to that. You are also aware, good Commissioner, that labor is activist and a political issue. Very, very unfortunate, because we can do it professionally. But from the onset, it has always been an activist. So what the judge does is stay aloof to all that, so that you are able to do your work effectively and without interference. You stay aloof of any sector, whether it is the employers, whether it is the employees, and whatever they say. You just take it straight, like every other Kenyan would do that, and maintain your distance. What I would like to say about that is, like I've said, good enough. Let them say it. The other one, the other answer, they are saying that don't touch my court. Who are they telling not to touch their court? Good enough. Their court. That's plain English. Do they own it? That's another issue. Is that going to really influence the decision making insofar as the court is concerned in government? Another one. Those are all issues which will come to the administration in this country, the political administration in this country. That is their desk. The judge sits here and remains neutral to his profession. Judgeship is a difficult matter. It's a job of denial. When you're a judicial officer, you must stay aloof, you must stay away, you must live alone. I thank God.
Thank you, Judge. Thank you, Judge. Now, let me end up by seeking some clarifications here. One is your card from People with Disability Council, I don't know the name, where it is written visual stroke mental, and you saw it the first day. It is now 6 years. You even went ahead and told us that a friend of yours who knows the repercussions or the effect of having that statement on your card, he told you to be careful because it can bring in issues. I'm not convinced that you just ignore it like that, because it's a very serious issue. The issuer of that card is a statutory institution that is technically qualified to recommend, and we cannot challenge in as far as their decision is made. But now that you are carrying that card for all those years, didn't it cross your mind that one day or one time you will be haunted by the writings on that card?
It has never occurred, and the judge, we have our own personalities which we are entitled to. We have our own creations. I have over 340 leave days left, a balance with myself. I am a workaholic. I am not, my personal look is not myself. I'm missionary. I love it when everybody else is happy. So peripheral issues like that one, now it has become an issue today. I don't know for what good or bad reasons. I can address it. It just requires me a day or two. Unfortunately, I'm not a Nairobian, but I can invest that time there and have it done. But it never occurred to me that it was, if you ask me, it was a non-issue. When I was addressed by the expert, I said I would do it. But it's not in my style to just touch on anything which I have no regard for.
Okay, Judge, so are you saying you are going to amend it? Are you going there?
Instantly. In fact, tomorrow.
Okay, thank you. My other clarification that I wanted to seek from you is about this driver issue. Why are you so particular about one driver? I thought driving, you are driven to work, you are picked, you are taken home, even if you are passing by a supermarket, this normal way. Why do you want a mwangi? Why not a driver that when you give instructions as like anybody else, like an average human being, he will do it? Why are you insisting? Why do you want?
I'm not insisting on mwangi. We can get it back, or we may not be able to get it back.
Yes.
Foremost, I'll insist on all the monies are paid to my drivers if the issue becomes an issue. Referred of whatever I've expended on the drivers in the last 13 to 6 years. if it becomes an issue. I have a driver as we speak. He's around, Stephen Kiprop, whom I acquired in my Kericho and Eldoret days. We are buddies. He's just my small boy, 28 years, and good to go. I would have, I would have anybody for a drive as long as you are able to meet what my needs. And my needs are sensitivity. I cannot drive. Even if I would drive, I'm not a good driver. I am a person with issues of health. So if you leave the car here, I would have to carry it. That is what you are saying. So flexibility, understanding is very, very important. If I become CJ, I may require more than one driver. We can pick Mwangi.
Yes.
If I don't become CJ, I'm content with Stephen Kiprop. Would you want us to absorb him tomorrow? I'll be very, very happy. I can even forego what I paid them all these years.
But Judge, going to the extent of even, paying, looking for your own driver, don't you see it is like off the mark, like it is not ordinary, it is not like any other person. You are totally different.
Yes, I am totally different. If you give me time, I would be able to tell you where I'm coming from. I wish you, Chair, give me some 2-3 minutes.
Go ahead, Your
Honor. If you look at the MBTI, that is a Myers-Briggs type indicator, there are 16 personality types in the world. That is the science of personality. I belong to one of them, the INFJ. The INFJ is 1% of the world, at most 1.5% of the world. And not on sampling. You don't sample 100 people here and imagine that one of them they are randomly all over. So you'll never be able to know when you meet one unless he confesses, etc., like I'm confessing. I only learned about this just the other day. But all my life, I've always known that I'm not an ordinary person. I have my issues. There are some things I take so passionately. Everybody else takes them very casually. I is introverted. N is intuitive. F is a feeling. J is a judgment. Those are my 4 qualities. The INFJs of this world are very introverted, very quiet persons. I could be in between INFJ and anything else because I'm just very verbose. What we are saying is that this is a special kind of person who is extraordinary and who cannot relate with everybody else.
So we have understood. So tell me now, you are applying for a position of CJ. That is a very senior position that you will be managed. You will be managed. Listen, you will be managed there. Sometimes even your diary is being managed by somebody else. You are guided. You are told move from here to there. There is this press conference. There is this meeting. They are talking notes here. How will you manage with you said F and something?
INFJ, you should have allowed me to complete, and I will still that's half a minute to do that. INFJs are the best leaders in the world, but they don't go for it. They don't get out to get it. When you give them a chance is when you appreciate, and that is why this country should be given DK Marete for the Chief Justice, because it will be extraordinary dealing with this situation, and the results will be excellent. Idragadi and INFJ, I could give you other examples, but let me stop there.
Thank you, Judge. And finally, on this segment, I want you to, because these are the decision makers on whether to give you a job or not, can you assure us that you will not come and say, I don't want CRJ, I don't want DCJ, I don't want these members of the Supreme Court, I don't want even the way the building is organized. Can you give us an assurance so that when we are going forward, we know that we will not enter into a cost that we will not even manage to
I am not
bear.
going to take any Bible.
Thank you, Chair. Then thank you, Judge.
I am not going to take any Bible and make any swearing whatsoever. But my personality tells it all. My policy as a person is one humanity, one equality. We are all equal. In any event, who would I be to come and dictate that we don't require A, B, C, D, and E here? It is demonstrated throughout my character that my personality is all-encompassing. We have my wife has been here for 38 years. I've been here for 6 years. No, not 6, 10 to 9 years. None of our children is anywhere near here. We have never aspired to bring them on board, etc., etc. So there is no possibility that I would choose to work. Those who know me closely, Kericho, Eldoret, and Nyeri, those who know me closely and would like to tell a true story, know that I treat everybody on their own merits. And that is how I've dealt. I would be the last person to want to come and want to say that I don't want A, B, C, and D. It is not, I cannot even imagine it.
Very well, Judge. You have answered. Thank you very much. Thank you, Chair.
Thank you, Commissioner Koskei. Thank you, Your Honor. I now call upon Commissioner Orwande to ask the last set of questions. Commissioner.
Thank you very much, Chair. Good afternoon, my Lord.
Good afternoon. How are you?
My Lord, I like it that, like me, you believe that employee motivation and welfare is a significant input towards improving service delivery. And I'm aware that you once vied to represent the KMJA as a male representative in this commission. So I believe you're alive to our issues, and I'm certain that you don't believe that a ban to accompany the tea that we take at 10 o'clock would be motivation or a welfare concern. So I want to ask you, Judge, to give 2 issues aside from salary, and one which you've already raised, which is training, 2 issues which are welfare concerns, which, if addressed, would motivate the judicial officers and staff in this institution.
Accommodation is one. We have workers. They are physical, beings. We have no emotional attachment to them. It is good to nurse and accommodate our workers. That is the only way. If you don't buy them, like I'm saying and saying repeatedly, if you don't buy them, if you don't cajole them, if you don't accommodate them, there are issues. Most of them are very, very young people. They have children and baby. They are in the stages of babying, etc., etc. So their social welfare and all other terms must be accommodated by the employer very, very, very well to motivate them. You must recognize them, their humanity, their personality, their issues, etc., etc. I remember in Kericho we tackled a case of one of our officers who had issues with a drink, and very successfully, but it refused to work because of a relapse and what have you. We even took him to some place in South Nyanza as a gym. That is what we are saying. Let the employer engage more, invest more, not even invest in anything physically, emotional support, concern, love, so that we get home. Number 2, you don't work alone. You should be able to get these people together, either in gangs or one big gang, and they nurture that kind of a spirit of a group. a group which we can call and tell them, we do this because of A, B, C, D, and E. If Kenya grows, we all grow. So get these people to tie together, like each other, nurse each other, assist each other, be a party or a partner to them insofar as their welfare is concerned, insofar as their unity is concerned, insofar as their harmony is concerned. Things which may not be very high sounding, but very, very important insofar as staff morale, staff productivity, staff welfare is concerned.
Okay, thank you, Judge. Do you believe in mentorship, and do you practice it? And if you do, can you give us examples of judicial officers, for instance, or judicial staff that you mentor?
I have friends in the judiciary. Mentoring would be in involvement in that direction. I may not have any particular case of anybody I mentor, but I mentor in the air. I am a living teacher. That's why you find me shouting all over, and I don't give there are no issues about that, because wherever I sit, I'm teaching. By the time you leave this place, you have gotten so much from me. The teacher in me does not keep quiet. That is a part of my mentoring. Whenever I find anybody, how many people, anybody I find, yourself included, if we had 1 minute with you, have you gone back to college? Are you writing your other degree? etc. That is where I am, the personal development and concern for everybody else. Many of the workers in the judiciary are now my children. I deal with them as such. I nurse them. I parent them. Not that direct mentorship, but mentorship in a broad sense of the word.
Thank you, Judge. Now, you were once subject of investigation in a tribunal to remove you, and without necessarily going into the decision of the tribunal, I just want to ask you, because the issue that came up, one of the issues that were discussed in the tribunal concerned an order that you gave, which was considered sub judice. Now, I want to ask you whether you think as a judge you ought to concern yourself or be guided by the consequences of your decision. To put it in context, in the matter before the tribunal, the allegation was that one judge in Nairobi had given an order against a strike notice, and the affected parties appeared before you subsequently and sought protection, essentially, from the consequences of disobeying that order. So that in the long run, you are in effect insulating these, the people before you, let me just call them the employees before you. You're insulating them against the consequences of the order that was given in Nairobi, bearing in mind that the order in Nairobi was given before the matter before you. Could you comment on that, please?
It is unfortunate that I have to engage on that one. This is a judicial service of Kenya, and they handle that matter. But shyly, let me tell you that one, you know the periphery of the matter. The matter was more complex. What happened is that the JESC asked me to answer that matter, and I did answer. And the answer I gave, I did not suppose that anybody would require any more efforts. I do not like this. To ask me
I'm not even questioning the decision. The question I'm asking here is, as you make a decision as a judge, should you have a broader outlook, so that the consequences of the decision, other than looking at the letter of the law, the consequences of the decision that you make, you take them into consideration as you make your decision?
You look at that, you are right. You must look at it 360 degrees. But as you look at it 360 degrees, when you're through the first round of 360 degrees, you must come back 360 degrees and ask yourself, should I not do this? What are the other consequences? So you have two sets of consequences. The set of consequences which would occur if you didn't give the interim orders, and this other set which would occur if you issued the interim orders. Now, and that is why this matter is so ugly. I answered all that because I cannot answer your question without referring to the substance of that matter. Allow me to get into that, just a little bit of it. I pray that we shall not be playing around with anybody else, because I would be so sorry. I'm a peacemaker. I don't like confrontation, but
you don't have to respond to the merits of the matter. It's just that concept I wanted to get, and I think essentially you have responded.
You must look at it all out. 360
Thank you.
degrees.
Thank you, Judge.
You should also look at the other way, 360 degrees. That is my answer.
Thank you. Still on the tribunal, but from another aspect.
Please.
You filed a case against the JSC in an attempt to arrest the proceedings before the tribunal.
Yes.
Now, to put the matter in context for us, and the rest that maybe would want to know, what were your grievances in that matter? And secondly, having gone through that process, are there any deficiencies that you noted that you would wish to have addressed, or that you would wish to have us relook?
One, a good commissioner, that matter is alive and in court at Milimani. Petition number 88 of 2019 is alive. So we could be bordering on one or two things. Although sub-judice has been used as an excuse to run away from facts. I don't know whether I should move on to that. The JESC, to give a plain answer, as the pleadings, or the advocates have the pleadings. It would be rude to say that the easier way would be to look at it. Or you invite me onto we are colleagues. You can invite me into a private sermon. We can deal with that very thoroughly. You'll be able to understand it. If you wanted to bring it out here and we thrash it, I think it would be ugly, because it will cause confusion here. And we are warned, and very, very clearly in HR circles, that you don't go to your employer and start quarreling with him head on.
It's okay that if it makes you uncomfortable to address that question, it's okay, we can leave it. Now, maybe we can go.
The answers are very, very easy and very near myself, but it is not fair that we do it here with the JESC.
Thank you.
Invite me to a private section. We are colleagues, and the JESC and myself, we are all friends. I said I don't have any enemies, and we shall be able to thrash it. And I'll give you very satisfactory answers. And when I can't answer, we can research into it.
Okay, thank you, Judge. Now, sexual harassment. In the Judiciary Code of Conduct, sexual harassment has been given a wide scope. We have included in it the meaning assigned to it in the Sexual Offences Act, in the Public Officers Ethics Act, and in the Employment Act. Now, I was looking at the definition or the meaning assigned to the term sexual harassment in the Employment Act. Basically, it has been said to mean a request for sexual favors which contains a threat of detrimental treatment or a promise of preferential treatment. Now, considering the power dynamics at play in a relationship between a junior employee and a senior employee, would you say that a request of this nature from a senior employee to a junior employee has in it, or has imputed in it, either a threat or a promise of that nature?
One would have to get to the facts of the matter. your definition of sexual harassment is respectable. When that happens, it truly amounts to harassment, because there's no consensus insofar as the matter, the request or the lack of request, that interaction is not permitted by one of the parties, and therefore it becomes an issue. To be able to answer you precisely, you require to get to the facts of the matter. You require to get more evidence, more details to answer your question. But as we speak, misconduct to that extent, from a junior officer from a senior officer to a junior officer, or vice versa, by your definition, amounts to sexual harassment. And it is primitive, it is not permissible, it should be eradicated, it should be outcasted. My words.
That it's not my definition, it's the definition in the Employment Act.
Thank you.
And the essence of my question is, by virtue of that relationship,
yes,
the fact that, for instance, I'm a junior employee, I'm a chief magistrate, and hypothetically, a judge of the Supreme Court is asking me for sexual favors. The dynamics of the relationship between us, clearly, from where I sit, it can be implied, or it can be the element of threat or promise is sort of implied in that request. That's essentially what I'm asking. I don't know if you're getting my question.
No. You can relate to that. You have the liberty. Your natural human right to relate with anybody of your choice. And the relationship are not an issue of a status or office. A relationship is an issue of a consensus. You can relate with anybody. I don't want to give my example, unfortunately, or your example, but where I say you, I don't mean precisely you. I mean any of us. So in that case, we would permit that kind of a situation, particularly if it is wholly and out of for serious business, like marriage, etc. If it is not any other, although I don't want to be a moralist, we are saying the issue is not the office. The issue is the conduct of the parties, or one of the parties. That is what would constitute the offense.
Okay, so I understand you to mean you do not agree with that analogy.
No.
Okay,
I agree with it. Only my clarification is that this thing is all round. You can relate this way. Anyway, the issue of status in a relationship doesn't arise. What issues would look for is whether it was mutual or not mutual, where there was a violence or not no violence, whether there was inducement or no inducement. That is what we look for if we were looking at it. The one that I taught my criminal law in law school, 1981. I've done almost 0% of criminal law ever since. I'm not a criminal law practitioner, but I'm a lawyer.
Thank you, Judge. Thank you, Judge. I've gotten your answer. Now, I have looked at your application and the papers that you filed accompanying your application, as well as the reports we got from the statutory bodies through which we were vetting you.
Yes.
Starting with your application from JSC 2A.
Yes.
In your self-assessment.
Yes.
You described yourself, let me just read it.
I have it here.
I am a scholar who may have been misplaced at a crucial stage, as is demonstrated by my academic pursuits now at PhD level. This piqued my curiosity. What exactly did you mean by misplaced?
What I'm saying is that from day one I was a teacher. Somewhere along the line, maybe become maybe a lawyer, etc. issues of influence, issues of status, etc., etc. But basically what I was saying is this. I would have gone up the ladder and become a teacher in some university somewhere and enhance that to professorship. I admire what your name, good chair. I would have wished that for myself. And I may get it someday. After retirement, we are going to pursue these things. So along the line, things happened, and things which were out of our control, and we are not in that line. That is what I meant.
I was a bit concerned, Judge, because it gave me the impression that being a judge and ultimately maybe a Chief Justice is basically a plan B for you.
No, no, no. I chose to do law. One, because of my issues of justice and issues of service to society. But even in law, and I would still, I may not be Chief Justice if I was a professor in law, unless I choose to relinquish that and come back to this area. What I'm saying is that it is not an accident that we are where we are. But teaching, I'm a very big respecter of teachers. The other day I was accused of calling GK Kuria advocate, Mwalim in court, and there was an issue of a recusal, and it worked. I respect the teachers. I mean, I respect intellectuality. I like research of knowledge purifies me. In fact, these 2 months you've given me to read, I loved it. And that is where I am.
Thank you, Judge. Okay, again on your form, the form that you fill, JSC 2A.
Yes.
You are required to give a total of 5 referees, 3 professional and 2 character referees. You gave 5.
Yes.
But 4 out of the 5 were unresponsive when we sought their opinion on your character.
Yes.
And you as a professional.
Did you get them in the first place? That could be the issue.
But what I'm saying is they were unresponsive. We did not get a comment from them. And this is of concern to us, and I'm wondering, do you know them, and would you know the reason why they did not vouch for you?
I suspect that it was a communication, the addresses. 2 of them are in the chart, the personal referees, character referees. 2 of them are in the church in Mbagadi and up there on Gatarongai, etc. One is a church elder, the other one is a church minister. Those were the character referees. The others is my colleague, was my colleague at the Nazarene University, Professor Mbodenyi, some teacher of mine at Nairobi University, and an advocate who works at the Meru County and is also an advocate in Meru. I trusted him because I thought we were in school together. We had worked very, very briefly at the AG chambers before he left in Nyeri, and I trusted that the other limb of your question. When I issue referees, I don't go to them or even alert them that they may expect A, B, C, and D, or coach them. That is how open I am. I leave it entirely to them to give any information that you may ask, etc., etc. If you haven't, I am available now, today and tomorrow. I could carry those things to them. Dr. Akunga Mamai, I cannot commit myself on that. Parklands is a difficult area, I may not be able to see him. As to whether you'll be willing to do a commentary on myself, I cannot answer that. He taught me about 15 years ago, 205, 206. This is 1610. This is 13 years ago in my LLM program at the University of Nairobi. I'm not even sure whether you wanted to do that. But teachers are the people we look for as referees in academics. So he has that, but I cannot promise you that I'll be able to get him. I'm not sure whether Professor Bodenyi has done that. He's available. I can get him. So if you wanted me to pass these letters of inquiry to them, I would do that. As to answers, I will not bind myself on that, because the best I would do is pass the letter and leave it to them. And
okay, thank you, Judge. We were just concerned whether these people know you because they did not respond, but you've already responded to that.
They know me very, very well.
Thank you. Thank you.
Very well.
Next question concerns the wealth declaration.
Yes.
Before I can address that, maybe I would want to hear from you, Judge. Why do you think we require you to periodically file wealth declarations, and even at the time of filing your application?
The rationale behind wealth declarations was issues on integrity. The ESCC, and particularly we may call it right corruption. That document will be able to tell you that Judge Marete, before he came to the judiciary, owned blah, 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 blah. After the judiciary, A, B, C. And then you would have to make your own conclusions. You are sharp and good. Those who manage that are supposed to be experts. Even the best of idiots or fools would be able to look at that and say, now, this doesn't make sense. Judge Marete owns some property which is $500 million. I also would find it difficult to imagine that. So that is the essence of all declarations.
Thank you, thank you.
We do them.
It gives us an avenue to be able to probe and maybe audit.
True.
Thank you.
Yes.
I looked at your wealth declarations. You are required to submit 3, the last 3, and you did.
Yes.
But some concerns were raised, or I have some concerns.
Yes.
Concerning the declarations that you filled.
Yes.
That give rise to my questions.
Please.
Judge, you earn a salary.
Yes.
That is income.
Yes.
In the 3 declarations that you filed,
Yes.
you've indicated your income as N/A. What does that mean?
Not applicable.
Why is that?
My answer to that is that in my own imagination, my cleverness or lack of it, is that when you're asking for income, you're asking for extra, not my pay. Because I imagine that you know my pay, everybody knows my pay, it's public knowledge. So it's extra income. Do I do business? Do I farm and sell produce? Etc. That is why I answered it that way. If I thought differently, or if I had your idea of what income means, the answer would be very clear.
But you realize that we started off from the premise that that would help us do some sort of audit, so that we're able to look at, you gave the example that if someone said you owned a property worth 500 billion, we would question, on what basis would you question that if we do not know what your income is?
You know, well, declaration, the concept and the law came in 2003 after the NAC revolution in 2002. We have dealt with it from our TSE days, up to where we are. And all this time, my conception of income was anything apart from salary. That's where I went wrong. In the future, I am learning, and even on that one, if you wanted a statement on my income in those years, salary available.
Great, then you can supply us with that before this process is over.
My pay slips, I'm scattered all over. Some of my service in Eldoret, some of my service in Nyeri. I have not moved from Eldoret. That may be a tall road, unless I ask my employer to give me extra details. If that, and I cannot work on anything which I am not in control.
Okay, let me leave that to you. Another concern I had about your wealth declaration is that
am I allowed to ask a question? Yes,
Your Honor,
because she has left it to me. Does that mean that I would have to do it, or is left open? Because I can't see myself being able to go and go walk through Eldoret, get the pay slips, go to and those are old ones. those are many, many years ago. It may not be practical before you clear the exercise. But I can promise you that, say, the next, how many months? We are in before the close of the vacation, in the summer vacation, in September, I'll be able to give you that. And if you require it, then please tell me so that I can look for them.
Commissioner, rather maybe you can explain how many. I think it's the last one that you need, not all of them, or the latest.
Okay, Judge, the advertisement required you to supply the last 3. You supplied.
Yes, all declaration forms.
Yes, you supplied for 2016, 2018, and 2020, and all of them had that anomaly. They did not have.
It has been permanent from 2 or 3.
Yes.
Yes.
And what I wanted to say is that the advertisement was there, and it is for you to comply. That's why I said we are leaving it to you. If you are talking about September, I do not believe that this commission will put this whole exercise off until September, when you can avail your wealth declarations. So I still maintain I leave it to you, or we leave it to you, to see if you can supply with whatever necessary information that we may need before determination is made. On the next issue,
Judge, you can finish what you are saying, Your Honor.
Yes, I was moving on to the next issue that I have with your wealth declaration, if you can permit me. Again, in the description of assets, where you're supposed to indicate the assets that you have, I noticed that you did not disclose your bank accounts. I do believe you have bank accounts.
Yes.
Or at least even a bank account.
Yes.
You did not disclose that.
Mm-hmm.
I also noted that you did not file a separate statement for your spouse as is required in the guidelines on that form. And another crucial one that I noticed is that in the wealth declaration, the last wealth declaration that you filed in 2020,
yes,
you had acquired a new property.
Yes.
Somewhere in Ngong,
yes,
worth 30 million.
That is not a new property. Good. Please ask your question and finish so that I can answer.
Yes, the challenge I'm having, again, on the same premise that we had agreed on earlier, that these declarations help us to make an assessment and do some kind of audit. You do not have a commensurate loan, because I would imagine probably it's a loan or a mortgage that you've taken, worth that amount of money. Your income has not been indicated. This property worth 30 million does not appear in your wealth declaration of 2016 and 2018.
Yes.
So I presumed it was acquired between 2018 and 2020.
Yes, that property worth 20 million is
30 million.
My home in Ongatarongai. I entered that property on the 1st of September 1996. It was 30 million even before I got to the TSC. It was 30 million even before I got to the Judiciary. So if it is not appearing on my other wealth declaration forms, it is an error. It would, and I believe I should have, and I have always wanted to it is my prime property. In my own imagination, I always give it as a part of my wealth. And if I have not done it on any of the others, that is an error. I can correct that in a write-up or any other by any other means. That is a property I've owned almost virtually all my life. 1996, and today is almost 30 years, or well over 25 years.
Okay, thank you, Judge. I just want also to bring it to your attention that we, in the process of vetting, doing background checks, we received a complaint from one Eric Kiprono Koech. We received your response to it, and I do not have questions to that. I will leave it for the consideration of the Commission. Thank you, Judge, and I wish you well.
Chair.
Yes, Your Honor.
I have issues with the commissioner. She has raised an issue on bank statements. She has raised an issue on my wife's income, and lastly on the complaint. There's something I did not get, and when I get all this, my question will be: does the commission expect a response on this? I have noted bank statements, I've noted my wife's income, and I've not answered it. I could answer that, be allowed to answer that, or be enabled to answer that. The complaint is done itself, I answered. So what was the other issue?
Judge, if you have an explanation, please feel free to give it. An explanation as to why you did not file a separate statement as required for your spouse, and any other issue that I have raised. Please feel free to give that explanation.
So there are three issues: the issue of my 30,000 property, 30 million property, the issue of bank statements, and the issue of my wife. Do I answer the one for my wife and then have a balance of the two?
Please answer whichever you want to answer.
Yes. My wife is a retiree. She retired 3 years ago. She is not doing anything. She's around 63 or so years. She's just at home and resting. She takes a pension from the judiciary, 33,000 shillings, and eats it. Number two, misconception or wrong interpretation. All my life, from 2003, and that is why these things are bringing issues to me, I construed wealth declaration to be personal, and the issue of salary, the issue of bank account, the issue of my wife never arose to me. I'm learning now, and in the future I'll interrogate that and comply. So if that answer doesn't satisfy you, insofar as my wife's declarations, when she was in the public service, she would do hers, I would do mine. That was 3 years ago. She is not now. She's a pensioner. She takes her 33,000 shillings every month. Eats it or throws it away. That is not a matter which would really concern me so badly. But if you require me to do a write-up to that extent, I'm available.
Judge, like this is coming out of the vetting process, and this process continues until the commission makes a decision and nominates one of the 10 candidates. I just thought I should bring that to your attention. And what you are required to file under the Form 2B is a separate statement of your wife's income, assets, and liabilities. She may have retired 38 years ago, after serving for 38 years, but she may be having some assets. She has an income in the form of a pension. She may be having liabilities. That is what you are required to file. Thank you, Judge.
Thank you. We shall comply.
Thank you, Judge. And just to emphasize what Commissioner already has said, that we still have some time to submit those documents, because we can still consider them until we make a nomination.
Thank you.
Thank you. So, Honorable Commissioners and Your Honor, we have come to the end of this interview. And Judge, thank you very much for coming, and also for your answers and the discussion that has happened. Thank you for being very patient with the commissioners. I would like to give you a chance, Your Honor, to tell us anything that you'd want to tell us, or ask any question at this point.
Thank you, good chair of the commission. I must thank you so much for firstly affording me an opportunity to engage you on this auspicious occasion of the selection of the Chief Justice of the 15th Chief Justice of the Republic of Kenya. It is such a honor. Even allowing me to be here is a privilege. I appreciate and thank you so much. I thank you for the openness. I thank the people of Kenya for opening it up we had days when this would not have happened. 2, you remember the INFJ, the extraordinary leader? Here he is, a leader without any followers, a leader without office or portfolio. If you wish to do Kenya a favor, and a big one for that matter, here we are. We offer ourselves to demonstrate to Kenya that these things are doable. And we can do them in style and simplicity. I am simple, I am straightforward, I am reliable. I'm very, very focused and outrightly extraordinary and organized. If this is not the person we're looking for, we can debate that. But in me, you have that and extras. Thank you so much. When you sit and make your final conclusion, remember that messages come in the air. And to me, Kenya has spoken, and there we are. Thank you so much.
Thank you very much, Your Honor. We have heard, the commissioners have heard what you have said about your personality description. Did you call it INFJ?
FJ. Google B Myers MBTI, Myers-Briggs Type Indicator. You learn the whole science of a personality type.
Thank you, Judge.
MBTI.
We have heard and we wish you all the best. And once again, thank you very much for availing yourself for this interview.
Thank you.
Thank you. Honorable Commissioners, Honorable Judge Mother Koome, welcome to this session. I think we will take 1 minute for the photographs to be taken, and then we are going to start our session.
Do you have that question?
I think that is enough. Your Honor, Honorable Mother Koome, we want to welcome you to this interview on behalf of commissioners, and thank you for being here. And just to let you know that we hope it will be more a conversation so that between you and us, and please relax, Judge, and answer your questions as precisely as possible. The interview will be by all of us, the 9 commissioners. And now I'd like to the commissioners to introduce themselves. And I'll start. My name is Professor Olive Mugenda, Commissioner, representing the public, and also chairing these interviews. And to my right.
Good morning, my lady. I am Philomena Mbetemwilo, the elected representative of the Supreme Court to the Commission. and the Deputy Chief Justice of the Republic.
Good morning, Judge. I'm Patrick Ishohi, representing the public service.
Good morning, Your Ladyship. David Majanja, Judge of the High Court, representing Kenya Magistrates and Judges Association as the male representative.
Good morning, Judge. My name is Oluwande Evelyn, Chief Magistrate. I represent the female, the female representative, of KMJ. Thank you.
Morning, my lady. My name is Machari Njero. I represent the Law Society of Kenya.
Good morning, Judge. My name is Felix Huske. I represent the public.
Morning, my lady. My name is Mohammed Warsame. Welcome.
Very good morning, my lady. Kihara Kariuki. I am the Attorney General, and I'm a member of this commission by virtue of that office.
Thank you, Commissioners. Honorable Judge, if you're not sure of any question, you can seek clarification from Commissioners or ask the Commissioner to repeat the question, just so that you are clear when you're answering that question. So I'll kick off the interview, Your Honor, by asking you to tell us very, very generally, because I'm sure your fellow lawyers and judges will ask you more, but tell us generally what you perceive to be the role of the Chief Justice.
Thank you very much, Madam Chair. Thank you very much, Honorable Commissioners. Thank you for inviting me to this interview to defend my application for the office of the Chief Justice. The role of the Chief Justice is spelled out in the Constitution and in the Judicial Service Act and other statutes. The Chief Justice is the end of the judiciary. He is the President of the Supreme Court. He is the Chair of the Judicial Service Commission. He is the Chair of the Kenya Law Report Council. He is the Chair of the National Council on the Administration of Justice. In his role as the end of the judiciary, he delegates duties and responsibilities to the Honorable Deputy Chief Justice. He also liaises with the President of the Court of Appeal, Principal Judge, and Principal Judges of other courts of equal status, including overseeing the Chief Registrar of the Judiciary, who is the accounting officer. He also chairs the JOLAC, that is the Internal Leadership Committee, comprising of all the leaders of the various courts. He is the link between the judiciary and the other arms of government. He swears into office the advocates. He also swears into office the President, the Deputy President, and also the Constitution Commissioners. We have like 15 of them under Chapter 15 of the Constitution. He is the one who swears them in the office. I think when I'm Chief Justice, we will consolidate all those roles, write them in a booklet, and post them so that at a glance you can be able to see the role of the CJ, because there is more, like he advises also the President when to dissolve Parliament if they have not enacted the law. So there are more other things, but basically that is the role of the CJ.
Thank you very much, Honorable Judge. Please tell the Commission and the Kenyans who you are, Judge, in terms of you as a person, in terms
to understand that important objective of the Supreme Court. So we are all answerable to Kenyans at the end of the day. But now the court alone must show Kenyans that we are here solidly behind the objective that has brought here, that Kenyans has brought us here to protect and promote constitutionalism, to clarify principles of law and build precedent.
All right, let's get practical here.
Yes.
You get onto the court, and 2 or 3 of your brothers and sisters develop a resistance towards your management style. How does my lady deal with that? We're talking about collegiality here.
Yes.
How does my lady deal with that problem?